All rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear, or persons having business with the appellate. Draw near, give your attendance, and ye shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division, First Department. Please know we have 7.5 hours of requested argument time. So I'm going to ask you to please understand that this court is familiar with your case, your briefs, the record, usually more than you wish we were. So please ask for the time you need, not the time that you want, so that I don't have to do it for you. And know that even if I cut your time, and I likely will, that if my colleagues have additional questions, I allow the clock to continue. So if you're brilliant, you may get the time you asked for at the outset. All right? Okay. People versus Quaran Rich. Okay. Okay, 5 and 1 and 6. CLNC 2019 FL1 funding versus Bennett.
Good afternoon, Your Honor. For the appellant, 8 and 3, Your Honor.
Okay.
Respondent, 6, Your Honor.
6 and 1 and 6. M. Lucila versus Jessica H. is submitted. CJ versus Pasilico, Civil Inc.
The appellant requests 7 minutes and 1 for reply, Your Honor.
Okay.
Respondent requests 5 minutes.
All right. Let's do 6 and 1 and 5, and you'll probably end up with 7 anyway. Okay. Fishman versus Fishman. You weren't listening, but go ahead.
I'm sorry, I didn't hear.
It doesn't matter. What time do you want?
7 and response.
Okay, 6 and 1 and 6. People versus Saquon Jackson. Submitted. Jimenez versus Rossi.
No, Your Honor, 5 and 2.
Okay.
Respondent, 3, please.
5 and 1 and 3. Jane Doe 1 versus Kip Academy.
Appellant requests 5 and 2.
Okay. 5 and 2 and 5. Thank you. People versus Douglas Williams. Submit. Greenland Asset versus Microcloud Hologram. Do you wish to submit, or would you like?
I'd like to argue.
Okay, how much time? Okay, you are by yourself. 3. 3 minutes. Stevens versus Orton LLC. Submitted. People versus David Taylor. Submitted. O'Rourke versus Hammerstein was withdrawn prior to the call of the calendar. State of New York versus Daniel M. Okay.
Respondent request 4.
7 and 2 and 5. I think you are out shortchanging yourself. People versus Joseph Medina Hidalgo. Submitted. Lerena versus 975 Park Avenue. Okay. Okay. 3 and 4 and 5 and 2. FlexJet LLC versus Honeywell. Okay. 6 and 2 and 7. People versus Dylan Johnson Watson. Submit. Wilmington Savings versus Lau. Okay. All right. Let's do 4 and 1 and 4. First case on the calendar, People versus Quaran Rich. You may proceed when you're ready.
Good afternoon. afternoon, Your Honors. Isabel Patkovsky on behalf of the Legal Aid Society for Karan Rich. After a trial dominated by the older co-defendant's fraudulent trial tactics, Mr. Rich was sentenced to 17 years in prison, a decade longer than co-defendants who pled guilty. The court was wrong to deny severance, and in the alternative, Mr. Rich should be resentenced in line with the pleading and equally situated co-defendants.
Why don't you tell us about what the evidence shows that your client actually did vis-a-vis the other defendants who got much lesser penalties, so that you can kind of lay that out for the court?
Yes, Your Honor. So there was one co-defendant, Mr. King, who was charged with exactly the same conduct as my client, Mr. Rich. Every time the prosecution mentions one, they mention the other in the same breath. They got to the cell first. Mr. King got 7 years, Mr. Rich got 17. Another co-defendant was alleged to have brought the cane to the cell and also to have asked the victim his gang affiliation before. He was also a violent predicate, which is more serious than my client, Mr. Rich's criminal history. He was sentenced to 11 compared to Mr. Rich's 17. Another co-defendant who was charged with taking the cane from the defendant who brought the cane was sentenced in another gang-related case as well as this one. He was sentenced to 5 years on this case. Another co-defendant with a concurrent gang-related case was sentenced to 8 years in this case. And the defendant, Jason Williams, who the prosecution accused of calling everyone together at the beginning, calling everyone together, has in fact already had his sentence reduced by this court, as Your Honors are aware. He was originally sentenced to 6 years in this case, consecutive to 5 years in an attempted murder case. And this court concluded that that was harsh and excessive and resentenced him concurrently.
Counsel, your client went to trial, is that correct?
He did go to trial.
And all of those co-defendants that you mentioned, did they also go to trial?
No, they all pled guilty, Your Honor.
Thank you.
And I think that this court has approved slight differences in pre-trial and post-trial outcomes. I don't think this court has ever suggested that 10 years, a full decade of this young man's life, is an acceptable trial penalty.
And there was no evidence in, certainly in the video, that outside of holding the door, the cell door open so the others could go in, it doesn't appear that he even went inside the cell. Am I incorrect about that?
The video is less clear, I think, than the prosecution presents. It does look like he goes into the cell, then gets pushed back out. Then there's sort of a melee. The video of course, does not show what happens inside the cell because there's no video there. The complainant in this case didn't even appear to recognize my client at the trial. He referred to him as whoever is sitting next to Mr. Brown, Mr. Brown being the co-defendant that went to trial.
Counsel, with respect to your issue of severance,
Yes.
The irreconcilable defense between Mr. Brown and your client, my understanding on the record is that your client basically was a passive bystander, so to speak, whereas Mr. Brown was much more active to justify his 21-year sentence. Where was the irreconcilable defense where there was a concern that there would be spillover by the jury?
Yeah, there were a couple concerns here. I think the most severe one was the co-defendants introducing evidence of the gang's alleged post-offense coercion of the complainant.
Except that post-offense coercion of the witness, there was no evidence that your client was at all involved in that, and it seemed to me that the introduction of that evidence would help your client rather than hurt your client.
I understand that, Your Honor. I do think it's notable that the prosecution itself, in its response brief, referred to, quote, the gang's coercion of the complainant, suggesting that even though Your Honor is absolutely correct that it was the co-defendant who introduced that evidence of him doing this, I think there was some inevitable tarring of my client by association, especially in a case like this one. I think it did really taint the trial and perhaps helps explain why my client was punished so very harshly after this trial, even though the evidence that came out about the actual charged crime was really all known before the trial. This is not a case where the trial revealed some additional details that would justify it.
You don't deny that your client held the door?
No, we're not denying that. I think the video is, again, a little bit confusing about at what point exactly the officer presses the button, but clearly he's holding the door in some way or other, yes.
Thank you.
Thank you.
May it please the court, Brent Yarnell for the people. I'd like to correct the record on what the video shows defendant doing.
Okay, so we saw the video, so you can give us your impression of what the video shows, but you can't correct the video for us because we saw what the video shows, and you can't tell us that our eyes didn't see what we saw.
Sure.
So I will allow you to tell us what you think the video shows.
Sure. I mean, two critical points. One is, as my friend acknowledges, defendant rushing to pull the door open after it starts to close. And the second point, which you clearly see on the video, is you see defendant punching somebody before they go into the cell. So the video captures the portion of the fight that starts before all the co-defendants go into the cell. And during that portion of the fight, you can
So the
clearly...
punches warrant a triple sentence of this 20-year-old who didn't cut the complainant, wasn't the lead person inside the cell based on the video. He should get 11, 12 years more than the person who cut this guy?
Well, first of all...
And you think that's okay?
Well, first of all, I think my friend is making an incorrect assumption that the other defendants...
Answer my question.
Yeah,
You think it's okay for this young man to get 12, 15 years more than the person who actually cut the complainant in this case?
No, Your Honor, he got 4 years less than the person who cut the defendant in this case. Shaquan Brown got 21 years, defendant got 17 years.
And Williams, who orchestrated this whole thing, only got 8?
Well, we can't assume that Williams is similarly situated to defendants. So Williams got 6 years, which I would note is less than the minimum.
6 years is what we reduced it to.
Well, he got
Not what he got at sentence.
No, at sentencing, he got 6 years for this particular crime, set to run consecutive to a different crime, and this sentence adjusted it to have the sentences run concurrently.
Right.
For Williams, the reason for that was because he showed rehabilitative potential, which is something that the sentencing judge in this case noted was sorely lacking. But the other thing I would note about Williams, which is true for several of the other defendants.
And what was the basis of that? There's no rehabilitative of a 20-year-old.
Yeah,
There was nothing about this young man's history that was so egregious that anyone should say they are beyond redemption.
Yeah, it was a couple of things that the judge noted. I mean, first of all, there were his remarks at sentencing, which definitely showed a pointed lack of remorse. There was his behavior in the courtroom in front of the judge, including when the jury read the verdict, when defendant made an outburst objecting. And then the other thing is that he was given 2 opportunities to speak to probation. He didn't attend either of those opportunities, and probation said that this defendant, in their view, had shown that he's uninterested in
This is the same young man who wanted to plead guilty and couldn't because he was afraid of being beaten up by the same gang who orchestrated this assault?
Well,
Is that what we're talking about? Because we know from his counsel that he asked for a private audience with the court because he didn't want his co-defendant to hear what he had to say.
Well, first of all, we don't know how much of that is true. I would note that that defense counsel at sentencing made some claims that were a little different than what were made at the severance motion. So at sentencing, defense counsel said that actually his client was willing to plead guilty. He just wanted a lower offer than what the people were offering. So there's contradictory statements from defense counsel on that point. And with regard to the other defendants, I think it's important to note here, we don't have in this record a full record of why people got different offers, what people's offers were.
Counsel, would you agree that the 17-year sentence was high?
Oh, it was certainly high, but I would also note it's in the middle of the range. His range was 8 to 25 years. And I think the factors that the judge listed at sentencing show why a mid-range sentence for this defendant was appropriate, including the fact that the judge felt that this was not a minor role in the offense. She noted the enthusiasm, the energy the defendant showed. She noted the intense.
So having seen several of the videos, the defendant comes into play not at the beginning, not when they're jumping over the railing or when they're running to the cell, going down the stairs and so on. He comes at a later point and then holds the door.
Well, he's the first one that goes into the cell. So as soon as Williams tricks the guard into opening the cell, defendant and Brown immediately run over to the cell. They kind of stand outside the cell for about a minute, and then when the cell door starts to close, defendant and King rush forward, pull the door open, and then defendant goes forth alone into the cell. The victim pushes defendant out, and then you see defendant fighting with somebody. The only reasonable inference is the victim, in my view. At the precipice of the cell, you see that on the video, and then the whole group goes into the cell. And I would just finally note, we don't have...
Without the defendant.
Well, he goes in with all the other co-defendants. And
That's what you say. That's not what I see.
You saw the defendant go into the cell on the video?
on the video, you can see defendant go in alone, and then he's pushed out, and you see then a fight at the doorway of the cell, and then you see all the co-defendants going in together. What's a little harder to see is the victim in all this, but I think the reasonable inference is that they are fighting with the victim at the precipice of the cell.
Should we consider that he's only 20 years old at the time of this offense?
I mean, it's a factor, but the other factors are, the seriousness of the crime. This is a gang who, they initiated this. They decided they were going to punish somebody who was not their gang. They felt this was their territory. This was somebody who was encroaching on their territory. It was a serious offense. You have just the way that he presented himself to the judge, the disrespect he showed to the judge and the court, all these things that the judge took into account in deciding that he
Disrespected the judge because he reacted to a verdict?
Well, the line that I would put is, I don't think 7 people could cut somebody one time. I think to make a
I
claim
think
like that,
that's a decent argument.
I interpret that as him saying, if I really was participating, we could have inflicted much worse much worse injuries, and I interpret that as a pointed demonstration of a lack of remorse before the judge in the sentencing proceeding.
And you equate that as a lack of respect that warrants a sentence triple some of his other co-defendants.
Well, the point that I'm making is that these other co-defendants did not have the same sentencing range as defendant. So what is a medium sentencing range for defendant is not a medium sentencing range for the other co-defendants, and that's
Right.
essential for the court to take into account. We ask that you affirm. Thank you.
Thank you.
Very briefly, I'd just like to touch on 2 points. First of all, yes, Mr. Rich was upset when he was sentenced to what was essentially half his life. He was 20 at the time of the crime. He was sentenced to 17 years. He was also upset because the court wouldn't
More
let
than
his-
half his life, almost his entire life.
Excuse me, yes, his entire life at the time, half his life by the time he's done. He was also upset because the court wouldn't let his mother be there, and he was a young man who wanted his mother to be there. Second, I'd like to point out that if Mr. Rich were resentenced to the minimum of 8 years, that would still put him at, in fact, the upper range of what the co-defendants received, because the co-defendants received respectively 5, 6, 7, 8, and 11. That would give him the second highest sentence.
That's what you're requesting, correct?
Correct. And that would be lower than the one defendant who was sentenced as a violent predicate.
How many years has he served presently?
Well, he was, of course, incarcerated at the time of this, so it's been about 7-ish years. His maximum expiration date is 2037, as it stands right now.
Thank you.
Thank you very much.
CLNC 2019 FL1 funding versus Bennett. You may proceed, sir.
May it please the court. Mark Berman from Bond, Shenick and King for the appellant. We're here on summary judgment granted in favor of the lender against the guarantor by Justice Joel Cohen, a fine jurist. And I understand I'm coming before you where the appellate division affirms 99% of all
Don't
guarantees.
say that.
Okay?
Don't say that because that is a disrespectful comment of this court. We assess every case by case, and I don't think your numbers are accurate in any regard.
Okay, Your Honor,
Okay?
my apologies
We are
then.
assessing your case on its facts and on the law, so please don't do that.
Let's look at, Your Honor, there are 2 guarantees involved. And I would respectfully say what lender did is effectively move for summary judgment on reply, but I understand that moving on reply is sometimes overlooked. But let us just look at specifically the equity funding guarantee. And the equity funding guarantee, the lender contends they get to, it's binding, whatever the number is, it's conclusive, it's based on a good faith estimate. Now, to demonstrate,
Are you sure that's not the other guarantee? It's not the equity funded guarantee?
no,
it's
you're right, the cost overrun guarantee, Your Honor. Your Honor, my apology.
It's okay.
And so the lender says sole good faith. they need a basis for that. They need an evidentiary basis for that. We have the only basis in the record is the PCA, the Property Assessment Report. If you look at the moving papers, all the moving papers say this is a true and accurate document, and the numbers were from this report were incorporated in demand.
So, counsel, did the numbers in the PCA have to be accurate, or did the analysis have to be accurate, or rather was the document relied upon as a showing of good faith effort to determine what the proper number would finally be?
Your Honor, the numbers had to be accurate. Okay. Good faith in this case is not some esoteric concept.
So good faith means precision.
Good faith,
Good faith means it must be 100% right. If it's not 100% right, it doesn't equal good faith? Is
No.
that your argument?
no, that is not my argument. If it was $1, that would no be good. It was $10 million, it would not be good. But let's just go back. What we're saying here is, I'm saying that it needs to be of admissible evidence. This document is not a business record. None of the allocutions were made. There is no document, affidavit or otherwise, demonstrating on moving papers or reply papers that this is an admissible document. Your Honor.
But on what basis was it proffered into evidence?
It was not, I questioned on this document at the deposition, but for summary judgment purposes, there is no allocution or any moving or reply demonstrating that this is an admissible document.
But wait, you
Does
just
it
said
ha-
it
yeah.
wasn't offered. So the fact, whether it's admissible or not admissible, if it wasn't offered, I don't understand your argument then.
Okay, it was.
So this gentleman makes his opinion based on, in part, on this document, but he says this isn't the only thing that he bases his opinion on. So where does that leave you?
No, Your Honor. This document was created by a third party.
I
The
understand.
witness who testified was a former employee. In the questioning of him are the numbers that were contained in the demand contained in the report. No, they're not.
Counsel, if you look at the language of that guarantee, it says, and I'm just quoting a portion of it, it based on liquidated damages equal to the amount of such cost as estimated by lender in its sole good faith discretion. So you have the term estimated in a clear, unambiguous language in the cost overrun guarantee. That being said, if it's being offered not for its truth, but to show its good faith, and the PCA then suggests, among other required work that the lender didn't actually have to perform, among it was the HVAC system. I mean, when you take that number and the other numbers, that's how they came up with that number. That's a good faith estimate. That's fair. And the language says it shall be conclusive for purposes of determining the guarantor's liability. Counsel, it's the express language of this guarantee.
Mr. Shulman, I understand. But when you say good faith, a good faith estimate, you have to at least demonstrate somewhere in the record that the number in that report is there on which the demand is based.
I have a further
Testimony
problem
says
about
the
I have
number
a
is
fur-
not there.
excuse me, I have a further problem about the PCA. You seem to make a big deal of it not being a business record, but it's in the nature of an expert report. So it would never be a business record. It's a totally different kind of foundation that's required, and a totally different kind of rebuttal that would be required by you, which I don't think occurred in the record.
It wasn't proffered, Your Honor, as an expert report. It was a consultant.
Right.
During the
Who they were
transaction.
using as an expert for this purpose, don't you?
And, Your Honor, if you were going to do that, where is the affidavit, if you will, of this presumed expert talking about it? We got to understand, there's nothing there in the record at all supporting this document. But I understand.
You'll have time on rebuttal. As you see, your red light is on.
Will I have time, Your Honor, to discuss the
You'll
other
have time
guarantee?
on rebuttal, the 2 minutes that you have. You may proceed, sir.
Good afternoon. May it please the court. My name is Joel Hames from law firm McDermott, Will and Schulte on behalf of plaintiff respondent. Just to set the reset, with respect to the cost overruns guarantee, there's no dispute that the defendant guaranteed in writing to pay liquidated damages equal to the cost to complete the agreed upon CapEx improvements. The cost overrun guarantee gives plaintiff sole discretion to determine the cost of completion, and plaintiff relied on this assessment report to estimate the cost of the HVAC and the roof work.
So, counsel, let's parse the language that was just used by your friend over here. Does this mean that good faith would apply to anything that was offered by your client, even if it was wishy-washy?
So defendant, first of all, doesn't cite any authority that plaintiff is required to affirmatively prove and establish good faith as a prima facie case, particularly given, as Justice Cohn found, the discretion in the cost overruns guarantee that's given to plaintiff to estimate the cost of completion. Anyway, plaintiff's estimate, we're talking in the aggregate $780,000 for those two items.
But what if I make a number up? What if you come to me and I make a number up and I say, ooh, okay, the liquidated damages equals this?
Right, the language
Does
of
that
the-
work?
Well, the language of the guarantee allows that. But in this case, we're talking $780,000 versus a loan that they defaulted on of $65.5 million and a loss to my client of $40 million. So $780,000 in relation to those, I submit, are more than reasonable.
And if I read the record correctly, the number that your side came up with as the liquidated damages was based on a report prepared by your adversary about what would be necessary, no?
No, it was prepared by a consultant firm for our client. It was used as the basis to estimate the cost of completion. Contrary to what Mr. Berman said, the number for the cost of completion is in the report. It's on.
Is there any evidence in the record that contradicts that number?
None.
Okay.
So the cost to complete is in the report. And it's on, and the record R589 is the roof, and R594 is the HVAC. And what the number, and why he's arguing it's not in the report, is there is a number, a cost to complete the report. In coming up with the estimate, we've deducted the amount that was in the budget that they were supposed to put into the project for those items.
So you're saying the number wasn't arbitrarily selected?
It was not arbitrarily selected. It was based on this exact number in the report, less the amount that they agreed to put into the project, so, for these items.
So is there a basis to show good faith here?
Oh, I think there's a basis to show, first, I don't think we have to show good faith.
Your friend says, no, this was just fiction. There's no accuracy shown. Is accuracy an issue?
Accuracy is, no one's contested the number in the report. They haven't contested that the number to complete is inaccurate. They haven't contested that the number that they agreed to put in is inaccurate, and he's not contesting the math. He's contesting admissibility. With respect to admissibility, that's not an issue either. First of all, we did not offer it for the truth of the contents of it. It was offered for good faith, and for that, we don't need to prove it as a business.
Counsel, with respect to the equity fund guarantee, they didn't really challenge the number. They just made a big deal of the fact that the lender didn't actually do certain work. Am I correct? Because you did give the offset for the CapEx sum, correct?
Right, well, you mean the borrower didn't do the work?
The borrower did the work.
Right, correct. So he doesn't contest the guarantee, he doesn't contest the math. What he's contesting there is that there was this tacit or oral agreement to modify the language to agree to some pause. There's no merit to that argument. First of all, the language of the agreement itself forecloses.
You only require writing, you can't do it.
And there's no evidence of it.
And the fact that Mr. Reamer showed up and saw different things doesn't mean anything here.
Right, and as Justice Cohn found, there's no evidence of a pause. There's some.
And even if there was a pause, the contract language says very clearly there is no waiver. So even if you don't exercise a right you have, at a given point doesn't prevent you from exercising that right later.
Exactly, and the three cases that Mr. Berman cites, one is the fundamental portfolio case from the Court of Appeals, and this court's decisions in 110NC and Parlux Fragrances don't support his case. What those cases say is there could be a waiver if there's a clear manifestation of intent. And in this court's 110NC case, what the court said was, the quotes, the manifestation was, quotes, expressly stated both orally and in writing, end quote. That's not the case here. There's some self-serving statements by Mr. Clary, but that's it. Otherwise, the math is what the math is, and that's what the agreement says.
Thank you. I've given you an additional minute since we asked you so many questions.
Thank you, Your Honor. Going back to the issue of what's in the PCA or not in the PCA and the number being there, not being there, I would ask Your Honors, when you go back to look at record sites 1156 to 1159, and to look at those series of 4 pages where the Mr. Nichols, the former employee, testified as to what was and what was not in the report, and it was not in the report. What we hear now, this document was produced 2 days before the deposition. Why? I don't know. Good faith, it could be any number, but as long as this document is shown, it could be $1, $100, there needs to be no accuracy. The good faith and the cases used by lender are none of those cases have a good faith requirement in it. This is a provision that requires good faith. So for a provision that
Don't all contracts require good faith?
there's always an implicit covenant of good faith and fair dealing. But in this case, because good faith was a required finding, it is being offered for the truth of the matter asserted. And the cases that a lender uses don't have a good faith requirement, explicitly a substantive requirement in the agreement.
Your friend asserts that you didn't contest any of the numbers in the PCA. Do you agree with that?
The answer,
I mean, I understand that you contest its admissibility, but do you contest any of the numbers in it?
the document was not produced during the transaction. So during the deposition.
But in the motion for summary judgment, did you contest any of the numbers in it?
In the PCA, no, we did not, because the numbers that made it to the demand weren't in the PCA. But none of the numbers in that 200-page report done by the consultant were contested.
Okay.
Just going slightly, because
You are out of time, and I gave you an extra minute. So I thank you. We have your briefs. Have a good afternoon. Seja versus Pacifico Civil, Inc. The Honorable Ellen Gesmer is recused from this case. Should there be a tie, the court will follow its AD1 procedures in vouching in an additional justice. You may proceed.
May it please the court, good afternoon. My name is Clifford Gable with the law firm of Bergman, Fields, and Lamonsoff, and I represent the plaintiff appellant, Jose Ceja. This is a rather lengthy record, so I'm just going to focus on two isolated issues because we did brief this very extensively in our brief and in our reply brief, and the court, I'm sure, is very familiar with this case. The main issue here is, did the plaintiff trip and fall on debris in a passageway or debris in a work area?
Well, on this record, it seems clear that that the other side was focusing on whether the debris that was created was integral to the work.
Yes.
And didn't trigger a 241-6 issue, correct?
Correct.
And it's your position that based on Bazdarek, Court of Appeals seemed to have cleared this up in your favor, which would arguably require a reversal on that issue.
Essentially, Your Honor, I understand the way the defendant distinguishes Bazdarek, because on Bazdarek, the plaintiff there fell on
slippery
wrap that was applied, whereas in here, the plaintiff fell on
debris.
Asphalt that was excavated, okay? But This court recently decided a case called Murillo versus NYC Downtown on October 9th, where it affirmed Judge Cohen's dismissal, where a plaintiff, a laborer, was removing debris and fell on that exact debris. Plaintiff Jose Ceja was not doing that in this case, Your Honor.
In this case, there were two separate people who were, his job was to jackhammer and soften up the trench.
Right,
And
using a blowpipe.
It was the job of another worker to clear the debris and either put it in a dump truck or put it in the pile.
Correct. And the backhoe operator was responsible for excavating the asphalt and putting the debris in a spoils pile, and he placed the asphalt here outside, away from the spoils pile, in the pathway that Mr. Ceja had to use to connect the blowpipe. And that's why we claim it's a passageway.
And the record demonstrates that they created, through the use of combs, a passageway, basically, from the trench to the truck, which they needed to access in order to amplify whichever modality they needed from the truck, whether it be compression or whatever.
Absolutely correct, Your Honor, yes. In fact, the backhoe operator testified that there were about 25 such cones delineating the area, and the contract between Basilico and Con Ed specifically said that the workers were not permitted to walk on the property owner's property without express permission of the property owner.
This was a restricted area, am I right?
Correct.
Does that mean anything?
Yes, it means that this is a confined work area where the plaintiff was working, and that the pathway from the excavation site to the truck was, in fact, a passageway. He couldn't go anywhere else.
There was no other passageway.
Correct.
There was no other way for him to access from the trench to the truck in order to switch whatever application he needed from the truck.
Correct. Exactly, and that's our position, Your Honor. The only other issue that I wanted to address before the court today was the issue of whether Mr. Ceja was a special employee of Basilico. And that, to me, is also rather clear, because in this case, Mr. Ceja clearly worked for a company called Morley Contracting that had an agreement with Basilico to provide laborers, but only Morley could hire and fire him. Morley provided him with workers' compensation.
It seems to me that our case law on this issue clearly shows that he was a special employee, and the fact that Morley was the pass-through for the money doesn't change the fact that he was being hired specifically to serve as a crew for the other company.
Right, except that, in this case, it's still Basilico's burden.
That's your strongest argument.
No, but that's certainly an issue I think I need to address before the court here. And that, at the very least, there's an issue of fact based upon David Gonzalez's testimony, and he was the foreman on the job, that he didn't have to control Mr. Ceja's work. Mr. Ceja went there to work.
Was that based on Mr. Ceja's experience as a laborer in this particular field?
It was based on his experience and based upon the arrangement that Basilico had with Morley, that Mr. Ceja went there to do a job, and he did a job just like any other subcontractor would do a job.
Didn't he get wasn't he working specifically just on this project?
Yes, he was working on this project. He went to the yard that morning and was assigned to this project, but he wasn't employed by Morley, by Basilico. He was employed by Morley. Yes.
Thank you.
Okay, thank you.
Good afternoon. May it please the court. Patrick Lawless for the defendant's respondents. The Supreme Court correctly found that the piece of asphalt which allegedly caused the accident was integral to the plaintiff's work. The plaintiff had testified that the piece of asphalt that he had jackhammered out of the...
Was it his job to clear the asphalt, or was it his job just to cut up the asphalt?
No, part of it was for him to clear it.
His job was not to clear the asphalt. Tell me where in the record it says that, counsel, because I have reviewed this record, and it is very clear that there was another company whose job it was to do that.
Mr. Gonzalez had testified that the plaintiff and he had also placed debris onto the pile. So it wasn't just being,
So I
Part of it- part-
jackhammer,
part-
I stop, I pick up asphalt, and I throw it in
he
the
said
pile?
he said part of it, that's why he had the shovel. Part
That's
of it
what
was
he
the
was
shovel.
doing?
Yes,
Okay.
that's what Mr. Gonzalez testified. There was a backhoe that was removing the asphalt, but also Mr. Gonzalez had testified that he and the plaintiff had also placed material onto the pile. So that was also part of their job. Might not have been their main job, but it was also part of their job. And with
Was there
respect to the
any
issue,
measures that could have been taken to prevent this asphalt from being a tripping hazard? Could they have done something better so this accident would have happened?
Like netting, maybe?
well, I don't think it, I understand your question, but I don't think it matters. I look at, there's another case that this,
Doesn't matter?
well,
There's a small passageway from the trench to the truck. You have the pile of asphalt being dumped right next to that passageway. And you don't think it was important to perhaps put netting up that would have prevented any asphalt that gets dumped on the top of the pile and rolls down the pile from not intruding into the passageway?
in a case that I argued before this court, Matteo versus Iannelli, it involved a large ductwork that was blocking the plaintiff's path that he had to climb over. And this court still held that that was integral to the work and the plaintiff could recover under
let's-
240.
How about you answer my question, which was, again, why was there not netting placed on the periphery of this pile? Because if you dump rocks of asphalt on top of a pile, some of those rocks are gonna roll down the hill of the pile and end up in the pathway where your worker has to traverse. So
I still don't think it affects the fact that this was integral to the plaintiff's work, and it was,
as
he
you
was
say,
charged
I
with,
don't think so, but
he was charged with removing, and
no, he was charged with breaking and creating a trench. His job was not to remove. There was another worker whose job it was to do that with a backhoe.
even if it was his coworker that was doing it or someone from Basilico that was doing it, it's still integral to the work. The plaintiff testified that the piece of asphalt that he allegedly, he didn't trip on, he stepped onto and it broke.
So here's the part where I differ. It's one thing to say that the pile is integral to the work. It's another thing to say that a piece of asphalt, how big was it, 2 by 3? 1 by 2? 2 by 2 square?
It was a large piece of
It was
asphalt.
large. It's situated 3 feet away from the pile. So it's not like contiguous, it's not close to it. It's not a simple roll down or an expansion of the base, is it? It is something separate and apart.
Again, though, the plaintiff had testified that he had just jackhammered that piece of asphalt.
He didn't say that. He did not say that.
I didn't see that.
Okay? He did not say
was-
the piece I fell on was something I just jackhammered. Tell me where in the record it says
It does
that.
say, he was specifically asked, I believe it's page 1767, where he was asked, was that the asphalt that you were jackhammering? And he said, yes.
Counsel, is it conceivable here that if we were to bring life to this issue again, that it would be a triable issue?
No, I don't believe it's a triable issue.
Well, I didn't say that. I said, is it conceivable, given the argument you're making, you claim it was integral to the work, and they claim that there was a duty under the industrial code to make sure that the work area that he was working in is free of debris, and you don't really challenge the application of 17E2, forget the passageway issue, you challenge whether there's a defense to that, an exception which would be integral to the work. And that's why I raised the case with your friend Bezdarek, because the covering of the escalator by the plastic tarp was integral to the work, but the Court of Appeals, in reversing us, said that, well, maybe they could have used a safer tarp. So now let's analyze it in the same way. Would you agree that there's a possibility that it could be an issue of fact?
Well, I don't think that particular case is applicable. I think that's distinguishable because it's a piece of tart that's introduced. It's not something that, it doesn't overturn all the cases by this court and other courts that say when you're when you're doing demolition work or removing things, and part of that debris is integral to the work, a piece of tarp is something different. A plastic tarp is something different than debris that's being removed.
Okay.
Thank you.
Your Honor, I listened to the arguments. I don't think there's anything that I need to reply to.
Thank you.
The court heard everything. Thank you very much.
Thank you. Fishman versus Fishman.
Good afternoon. May it please the court, my name is Elliot.
Hold on one
Oh, I'm sorry.
Sorry.
That's all right.
Thank you. My colleague has to come back in the courtroom. Sorry about that. Now you may proceed.
Good afternoon. May it please the court, my name is Elliot Scheinberg. This is co-counsel and trial counsel Julie Sheldon, and we represent Allison Fishman, the appellant in this case. Ms. Fishman is respectfully asking this court to reverse the order on appeal on 3 distinct issues. The first issue is anchored in contract law and decisional authority regarding how to divide marital assets that were depleted during the litigation where a high-earning spouse refuses to work in order to advance his own career and does not pay any type of child support or spousal maintenance for at least
Except
3.5 years.
That argument relies on our disregarding the finding of the referee that the husband was, that the wife failed to prove that the husband had left his work for improper reasons.
I'm not addressing that. That's
Counsel,
exactly.
that was part of your argument.
Isn't that,
Continue.
I'm sorry, I understood that to be part of what you were saying.
No,
That his argument, that because he left his work voluntarily.
that's not the argument. I did
Okay,
not
then I
say that.
misunderstood.
That's what I heard, but so say it again then, because
No,
I
the
heard
argument
same
is
thing
when
she heard.
somebody refuses to work, that he left the issue.
And the court below did not agree with that argument, found the opposite.
Well, what happened was the husband here took a position.
Counsel, like I said at the beginning, trust me when I tell you we know the facts of this case better than you wish we did. Okay? So, that is not what the court found. The court did not find that he purposely left his job so that he would not, that is not what the court found. So please continue, because we will not accept that. That is not what the court said.
Well, he did accept a position at some point at no compensation in order to advance his career, where he had
What's
acquire an
wrong with
ownership.
that? He clearly explained that the business he was in, the 144s, was losing ground in the field. They weren't. There was only one firm that was actually successful in being able to turn those around. And, you know, there are a lot of avenues in business that get shut down. And people in business kind of shift and they find a new source. And it seems to me that the court below felt that that's exactly what this husband
May I
was
answer the court's question, Your Honor's
doing.
question?
There wasn't a question. I didn't ask a question. I just made a statement, but you can go ahead.
Your Honor said, what's wrong with that? I construed that to be a question.
I'll take
So
that.
please permit me to answer that.
Of
First of all,
course.
there's decisional authority and statutory obligations that says, for whatever reason you as the payor spouse, has the absolute affirmative burden of proof of showing that you made every effort to acquire a gainful employment. He admitted, he testified during trial that he did not do any such thing after leaving his first job. Secondly, there's also decisional
But the
authority.
special referee found that he had not engaged in any wrongful behavior by
The wrongful
in
behavior
his,
that Your
in
Honor
the sequence of jobs that he took. given the nature of the business that he was in, which involved a lot of risk.
And he had multiple witnesses to describe the position that he was in and how the downturn of the work that he had been doing.
We're not disputing, it's what he did after he left.
So,
that's
counsel,
important
it's,
here, because the case law sa-
counsel, obviously, there's a dissonance between what you're saying and what we're understanding you to say. So what are you referring to specifically? He worked at FBR, then he went to Jeffries Financial Group, okay? He left before the clawback provision kicked in, where he would have to return bonuses for 2 years, and then he became a partner with Live Oak Merchant Partners. Is that what you're talking about?
We're talking about what happened, as Your Honor just pointed out, in what happened in Live Oaks. He did not, as the statute and decisional authority obligates him to look for compensated employment. Not
Counsel,
once.
he's
He
been
brought-
imputed to have 500,000.
I'm sorry.
He's got imputed income of 500,000 a year, right?
Which is not consistent with what his earning history had been of between 1.5 million and 2.8 million. In fact, the case law, please, if I may just say, and this is in the brief, the case law is very specific and uses the term that you can't have children subsidize a parent's career. And that's what happened here. The case.
That is not what happened here.
You're saying that he earned $500,000 a year, imputed income of $500,000?
That's what the
And the
lower
children
court
were
found.
subsidizing him when he was earning $500,000?
He wasn't, because they.
There was never a pendite lati application by your client. So
most
there
cer-
was never a request for child support, for maintenance. Both parties agreed to live in the way that they had. The husband agreed to, after there was a complaint that he had stopped putting his paycheck in the joint checking account, and he again began doing that, and all the bills were being paid from that account. No?
No.
Okay.
Because the record shows that that only happened from, there was a status quo agreement that dated back to the commencement of the action. It lasted 18 months until October, the end of October of 2020. After that, there was absolutely nothing. There was a total and complete depletion of marital assets.
But after that point, they managed to move forward with adequate support without engaging the court by seeking any pendente
Oh, but they
lite relief.
did. Here was the point. In June, they had actual trial dates. He stopped paying support. In June 2021,
Were there pendente lite motions?
there was an agreement, there was a stipulation.
The answer to her question is no? There was no pendite lite motion?
Because they entered into a
Counsel,
stipulation.
please. This would go a lot easier if you just answer our question.
There was no motion because they entered into a stip.
Thank you. Thank you. We will give you extra time on your rebuttal, okay?
May it please the court, Paul Talbert and Bernadette Schneider of Donahoe Talbert LLP on behalf of the respondent Adam Fishman. We stand here at the end of this.
Counsel, can you address the question that Mr. Scheinberg addressed at length, whether Mr. Fishman's career choices reflected a lack of commitment to providing support for his family?
Sure, Your Honor. I'd start with, as Your Honor mentioned, there's the 144A transactions that he did at FBR. His decline in his career happened 2 years before the commencement of this action, when he had to leave FBR and he went to Jeffries. Jeffries was to build specifically a 144A practice there.
And that attempt failed.
Correct.
Miserably.
Correct.
Correct?
Correct.
They didn't close not one 144 transaction.
Correct.
And so his boss, who brought him to that entity, he got fired.
Correct.
Correct? So your client saw the handwriting on the wall. Have I missed anything?
You haven't missed anything. And I would add to that, Your Honor, that he was told that he was not going to receive a bonus, which lets you know the writing on the wall at Jeffries. He shared this information with Ms. Fishman. There was no hiding the ball there. Then they didn't believe that, so they subpoenaed the records from Jeffries. The Jeffries records bore out that he was told he was not going to receive a bonus there.
But counsel, I think your friend's objection, I'm going to call it an objection or counter to what you're saying, is that what is at issue is the choice to work at Live Oak Merchant Partners without compensation, and as opposed to getting a proper job or getting something that would be more lucrative. So was your client a slouch? Did he renege on his responsibilities?
No, Your Honor. He testified at length as to the efforts he underwent to find employment, other employment, since the 144A was closed.
And just to be clear, he also had there was a covenant for reemployment that he had to abide, or there would be a clawback of monies he had already received, which would be monies less available to support his family.
Correct. Correct, Your Honor.
Okay.
And in terms of the efforts, just to go back to your question, he testified that he met with two specific headhunters. Korn Ferry was one of them, a very large headhunting company.
Very reputable.
Exactly, Maven Search. He went on interviews during this period. He testified.
But why was choosing Live Oak as his landing spot viable or reasonable or responsible?
Sure, Your Honor. He testified also that when at Jeffries, he testified at length about this, when the 144A transactions were not successful, there was another member of the group there that was having some success in these SPAC area. And he got experience in that SPAC area, in particular working with his old boss at FBR, and helped work on a SPAC there, which I believe he closed with Jeffries. It was the only landing spot that was available at that time in order to leave. He didn't leave.
Did he renege on his responsibilities?
No.
He failed to pay child support, maintenance.
So there was no set child support or maintenance because there had been no pendite lite order, but all of the expenses of the family were being met from this joint account where his whatever income he was earning was being placed.
Yes, and
Including his post-commencement income.
Exactly, $1.7 million from approximately right before the date of commencement, with Ms. Fishman admitted they would use the bonus prospectively to pay their expenses during the year. So $1.7 million in post-commencement income was deposited to pay their expenses. Was it enough to pay the millions in legal fees that were necessitated by this action? Absolutely not. Nonetheless, between the date of commencement and the date of trial, the accounts reduced by a total of $275,000 only. That's it.
But your friend says that the children were supporting the father. That the father made $500,000, but that wasn't enough, and the children.
So there's different ways of looking at it, which was were the children supporting the father? I would say no. When you deposit $1.7 million in post-commencement income, given an illustration, I exaggerate for purposes of making the illustration. If Mr. Fishman deposited $15 million 3 months after the date of commencement, I see my time has expired, Mayor. If he deposited $15 million after the date of commencement, and at that point went to another job that didn't have a salary but had deferred compensation, which this is, it wasn't for no pay, it was a deferred compensation. No one can turn and say he failed to support the kids. The question is, the $1.7 million, that was the agreement that Ms. Fishman insisted upon. There's no evidence in the trial that it was insufficient to cover the expenses. She demanded that arrangement. He complied with that arrangement. When he changed jobs, he offered and said, give me $1 million on advance on equitable distribution. You take $1 million in advance on equitable distribution. From mine,
Which would have made her an equal partner in his venture.
no, Your
No?
Honor. No. What he was saying is, give me an advance on equitable distribution to continue so that I can do two things. I can invest to make money so I can pay support in the future in my new venture. And number two, from my $1 million, if you'll agree to that, because I need capital, what I will do is I will deposit into the joint account the amount of what my after-tax base salary was at Jeffrey. That wasn't acceptable to Ms. Fishman. And after that wasn't acceptable to her, she didn't make a motion for Pente Lite support then. She didn't make it in the 8 months between then and trial. She didn't make it in the 3 years between the date of commencement and the date of trial. And if you actually look, there was no request for retroactive support at any point in this case until this appeal.
Thank you. I'm going to give you 2 extra minutes since we interrupted you.
And I thank you. First of all, as far as retroactive support, I'm going to work backwards. That's mandatory, it's statutory, it's incumbent upon a court to make this support retroactive. No application needs to be made for that. So let me just get that
But
out
if
of the way.
there's also no basis for the court to order it, then why would it be appropriate? There's no showing that there was any need for it.
It's statutory. The statute says that a court must make it retroactive, and the court has to address why there may not have been a need. It didn't happen here. Justice Goldburn did not do that. But I'd like to please get back to some of the issues here in terms about a Pendenti Lite motion. The reason there was no Pendenti Lite motion was there were actual trial dates in June 2021. And the court discouraged the Pendenti Lite motion. They entered into an agreement in lieu of a Pendenti Lite motion agreement for support.
And we're not critical of their entering into an agreement rather
but,
than running to the court to deal with it.
Justice Manzanet had questioned
Right,
that
I just
particular
want to make
point,
clear
whether it was made, but an agreement for Pendenti Lite
I'm
support.
not the only one who questioned that, by the way, but it's
Okay, well, but the point of the matter is, there were several dates. The first trial date ended up being on November 9th, which ended up being 5 months after the original scheduled trial date. And the judge said, you're going to make a motion for Pendenti Lite relief while we're starting the trial now? That made no sense, so the party had entered into an agreement. And as far as the living expenses are concerned, the $1.7 million, if you look at the husband's net worth statement, the husband's net worth statement, which we applied, we say so in our brief, showed that the parties were living at $54,700 a month. And then he adds a TBD, to be determined, talking about medical expenses. After the parties separated, he incurred roughly $7,000 more a month for his own living expenses, raising it to about about $670,000 a year in those expenses. They lived that way for 5 years. 5 years, that is many millions of dollars. That's $3 million. They added $2.1 million in counsel fees. $1.7 million is not a meaningful contribution. That's all it was. It was for a few months, 18 months. They had 2 agreements. The first agreement was in June of 2021, where the husband agreed that he would continue to maintain the standard of living for the family, their ordinary, customary expenses from his own income. He said that. And then when he took a job where he wasn't earning any income, that breached the agreement. And there's decisional authority cited in this, in our brief.
Counsel, during this period when he worked as a partner with Live Oak, did the husband make no contribution whatsoever?
Zero.
So he relied on the
Everything was
contribution
that's
that
correct.
he had made by way of
Absolutely.
the post-commencement funds and so on.
Everything. And we cite, and with this I'll conclude, and we cite 4 decisions from this court, McInnes, Levovsky, Azizo, and others that talk about replenishing the marital estate when a party has refused to make support. And here we have an obligation pursuant to governing authority and a stipulation between the parties.
Thank you so much.
Thank you.
Menace versus Rossi. You may proceed.
Good afternoon, Your Honors. May it please the Court, Marcelo Buitrago, Buitrago and Associates, on behalf of the appellant. Good afternoon. Your Honors, you've made it crystal clear that you know the record very well, and I appreciate that, so I won't go too deep into it. The reality is this is a motion for summary judgment that was made by the defendant. It's an incident where the defendant claims that because plaintiff had a stop sign, it's automatically negligent by default. I believe to allow that would be reckless for many drivers on the road today. The evidence should have been taken in its totality. Plaintiff testified that.
What is clear here is they allow for the excusable default.
Yes, Your Honor,
Correct.
they did.
Not an issue.
Not an issue, Your Honor.
The issue is whether you have a meritorious claim.
That's correct, Your Honor.
Or in this case,
Yes, Your Honor.
a defense, so to speak.
I agree.
So anyway, so essentially their view is because she had the stop sign, ball game's over, we win.
That was a
And
decision.
your view is the judge should have carefully looked at the record, particularly her own affidavit or deposition where she said, look, I stopped at the sign, I looked both ways. At the very least, it's enough just to go forward and possibly go to trial.
100%, Your Honor. The fact.
Especially where we have a defendant who never notices her, doesn't see the car in the intersection, I mean, sees nothing.
Correct, Your Honor. The vehicle traveled 3 lanes of moving traffic before the impact. The impact was to the side of her vehicle. The plaintiff testified that she stopped. The defendant couldn't admit or testify regarding his speed or whether he had his foot on the brake or the gas. The defendant has an obligation to see what's there to be seen. Thank you, Your Honor.
Thank you.
May it please the Court, Ira Goldstein with Morris, Duffy, Alonzo, Fairley, and Pitcoff for the respondents. Your Honors, there's more than meets the eye to this case. So let me put everything in context. She approached this intersection, which is a one-way street for her, one-way street for my client. She stopped once. She said there was a concrete mixer truck to her right, which we all know what those look like. They're gigantic. She apparently inched up, stopped again, clearly because of this truck. Yet she should have, according to VTL 1172, proceeded to an area where she had a view of approaching traffic. Yet she proceeded to go.
She said she looked and didn't see anything, and that all of a sudden, your client's car came and hit her in the passenger side wheel, which means she was already, he hit her in the furthest lane, which means she traversed 2 lanes before he hit her.
Right, which is exactly why she shouldn't have proceeded. When she hit the first lane, which she entered.
Sounds like an issue of fact to me.
Well, not necessarily. She entered the first lane.
Counsel, you know that we have a strong preference for deciding cases on the merits, and where there's a dispute of this level between the parties as to what happened.
Well, there is
I would,
no-
excuse me.
There is a dispute.
Well, on its face, but when you look at the record, she admitted he was
Your
half a
client
block
doesn't
away.
see her coming. Why? He's driving forward, there's a car coming across his intersection, and he doesn't see it until he smacks into her?
Well, she said he was a half a block
The
away when she first saw
VTL
him.
says you have a duty to see what there is to be seen.
Not when a
So
car
if
barrels through.
he doesn't at least say, I saw her all of a sudden and tried to stop but couldn't, he says, I didn't see her. That's all I have in the record.
Well, that's pretty understandable considering there's a concrete mixer truck blocking her view. She proceeds
And
to barrel
blocking
through.
his too, right?
Well, he didn't have a stop sign and he had no duty. I mean, this case in Perez, a driver has no duty to watch for an avoided driver who might fail to stop or proceed with due caution.
Right.
And
I'm sorry, counsel.
Sure.
The Neverez case, are you familiar with it?
Yeah.
And Neverez was an opinion that made clear that the presumption that you're relying on, so to speak, that because she had the stop sign and you had no sign, therefore you win, doesn't rue the day.
Well-
Neverez made it very clear that in this kind of scenario, like here, it pretty much requires a trial.
Well, in Navarez, there was an issue of fact as to whether the defendant had the right of way. Here, there's no issue. He had no stop sign. I mean, as well, in Jenkins.
So are you saying that if I don't have a stop sign and a car comes into my way that isn't supposed to be there, I have a right to ram my car right into them because They shouldn't have been there.
Absolutely not. But the question is, he has a
I'm
duty.
glad to hear you say that.
He has to
So,
avoid.
because your client didn't have a right to keep on going, just even if she blew the stop sign, and she says she didn't, right?
Well-
And your client didn't see her, so he can't controvert.
Well, the question is, he was in the right lane. Should he have gone out to the sidewalk to avoid the accident? Should he have gone left into her or the
I'm
concrete
sure
mixture
that's a
truck?
rhetorical question, because you know you don't get to ask questions of the court.
Right, well,
But I thank you for your argument. You have a minute on rebuttal.
Thank you, Your Honors. I don't need the rebuttal time. Thank you all very much.
Smart man. Jane Doe 1 versus Kip Academy. May proceed.
Thank you, Your Honor. May it please the court, Dean Pillarella for appellants Kip Foundation and Michael Feinberg. Your Honors, whether we look to the verified complaint, the documentary evidence, or both, plaintiff's claims against the foundation and Mr. Feinberg should be dismissed pursuant to CPLR 3211A7. Here's why. Starting with the complaint. The verified complaint fails for the same reason that the complaints in Jane Doe 3 failed. Number one, it fails to allege any connection whatsoever between my clients, the foundation, and Mr. Feinberg, and the alleged abuser, Mr. Concepcion.
So, counsel, could you separate out the foundation from Mr. Feinberg?
Sure.
Because looking at the record at A49, paragraph 160, it says, on several occasions, students and/or staff were present when the abuse occurred. Looking at A50 in the record, second cause of action, it does say negligence against defendants Levin, Feinberg, Corcoran, Vance, Kip Academy, and so on. But then when you look at paragraph 170, it says the sexual assault, abuse, and assaults on plaintiff occurred when defendants Levin, I don't know how to say that, Corcoran,
I believe.
Vance, Kip Academy, Kip NYC, Kip Foundation, City of New York, and New York City DOE owed a duty of care to plaintiffs. So in paragraph 170, Kip Foundation is named. In paragraph 170, Feinberg is not named. So going forward, would you make a distinction between the two?
So, well, starting with Mr. Feinberg, right? He's not alleged to have hired the alleged abuser, nor is the foundation. He's not alleged to have had any involvement with the alleged policies at the academy. The complaint refers to his implementing policies in Houston, but Levin only applying those same policies at the academy.
Are you saying that the policies are different from location to location? I thought this was a national, across-the-board policy. Am I wrong about that?
As far as the complaint goes,
Kibbs Academy as an institution has policies, correct?
we have trademark license agreements, which we discuss, and those limit our powers with respect to the charter schools. None of the trademark agreements, certainly the trademark agreement in this record, does not allow us to hire, supervise, train students at schools, teachers at schools. We analogize that agreement to yes, Your Honor?
But you agree that the foundation took it upon itself to set policies for the schools that it was involved in creating, correct?
No, I do not, absolutely not.
So, wasn't that a large...
The philosophy of the school of being very, allowing their faculty to be very engaging and touchy-feely with their students, etc. That wasn't a part, and disciplining children. That wasn't a part of the policy that was integral to the entire institution as a whole?
It's not in the trademark license agreement. No, what this court was concerned with in Jane Doe 3 specifically was student discipline policies. I assume that Your Honor is referring to the 5 pillars, right, in the trademark license agreement. Those are not student discipline policies, which is what this court looked to in Jane Doe 3. They're not corporal punishment policies, okay, that are alleged in the complaint. That's what the complaint concerns, is corporal punishment policies.
But,
That's not
but the complaint alleges, and obviously we have to give it deference because this is a motion to
course.
dismiss, that defendants, including the foundation, quote, established policies and procedures that created an environment that precipitated and encouraged physical and emotional boundaries being inappropriately crossed by employees and students, close quote. So if that was in part what the foundation did, isn't that relevant to the sexual abuse that had occurred and a reason to not relieve the foundation of liability at this point?
The problem, Your Honor, is that pages 39 and 40 of the record, okay, detail the alleged policies. They are implemented according to the complaint, not the documentary evidence right now, by Levin prior to the foundation's existence in 2000.
So in fairness, before 2020, they shouldn't be on the hook for any allegations before 2020. That's what KIP 3 says, correct?
Before 2000, at least, at 2000, yes.
Right.
At the bare minimum, yes.
But after a certain point, and again, putting Mr. Feinberg aside, the issue is if they had the power to go to these charter schools and see that their license agreement was being maintained and upheld, which puts them in loco parentis, so to speak, which is what's alluded to in the complaint here, then at the very least, you should go forward a little forward as opposed to being dismissed.
I could briefly respond to that. So 2 things with that, briefly. With respect to the complaint, there is actually no allegation in the complaint that the foundation actually employed the alleged abuser.
I didn't say that. I'm very careful what
I
I'm
understand.
saying.
But that in and of itself is fatal.
You want to hook yourself on just that. We didn't hire him, so we're off the hook. And what our questions are about the policy, right? And so I understand why you want to keep on going to, we didn't hire him, so we're off the hook. I get it. But once you got there, you accepted the policies of Kibbs Bay Academy and all of their choices of how to run their program. You accepted all of those. And so once you're there,
No,
okay, you'll have time on rebuttal.
thank you, Your Honor.
May proceed.
May it please the court, Deborah Cohen, Newman Farrar for respondent Jane Doe 1. Not surprisingly, the court's laser beamed in on how I wish to respond here, which hopefully will make my job a little easier till your questions come. I think it's important to describe what was KIP, the Knowledge is Power program, in the year 2000. Which is an important year in this case because it was the year that KIP Academy received its charter. It was the year the foundation was created. It was also the year that Jesus Concepcion, the alleged abuser here, he's only an alleged abuser here as opposed to, as is in the record, where he pled guilty to sexually abusing 5 KIP middle schoolers during the same years that our plaintiff was at KIP. So 2000 was a big year. But here's what KIP was at that time. KIP at that time was basically KIP Houston, KIP Academy in New York, and then the foundation was created. Michael Feinberg and David Levin were KIP. It was their baby. It was their creation, the policies and procedures, what they thought as 25-year-old, inexperienced, maybe dedicated, but inexperienced educators believed was the way to, in their words, educate poor Black and Latino students. Their policies which was the no excuses policy, which we describe at length within the complaint, the storm ship trooper policies that Levin ultimately employed, that he and Mr. Feinberg had created together as an even more draconian approach when no excuses didn't seem to work in Levin's view in the New York schools. Those came out of them. They created it. They created the foundation when the opportunity arose based on the KIPP Academy's orchestra's public persona, its popularity. It brought in interest to the idea of replicating what they had created in Houston and New York. And so the orchestra was really the money driver, the fundraiser. And so they created the foundation because they had gotten a funder so they could replicate it around the country. But at the time we're talking about,
I'm hoping that you can distinguish Jane Doe 3 from our Jane Doe 1.
Certainly. First of all, Jane Doe 2 and 3, which were consolidated, the years in which they attended KIPP preceded tiny bit of overlap perhaps, but preceded Jane Doe 1. The major distinction with Jane Doe 1 is the court dismissed the entities and certain individuals in Jane Doe 2 and 3 because neither the KIPP Academy had not received its charter, and the KIPP Foundation had not yet been formally incorporated, and the court rejected any successor and interest arguments. So the main difference is the two entities clearly existed when Jane Doe 1 was a student. Not in 1999 when she first began to attend, but by the year 2000, both entities existed. So that is the major factual difference. And I would also add that the court in Jane Doe 2 and 3 left a little bit of room to cause me concern coming before you today, because they said it's not clear from the record that Mr. Feinberg or the foundation had been involved in policy-making, hiring, supervision, training from the record. So I came prepared to try and address that distinction.
I would like to address that very specifically. It appears to me that the only cause of action you're claiming is against Mr. Feinberg is the second cause of action. What's notable is that the second paragraph of that cause of action, paragraph 170, lists the defendants who you seem to be claiming violated the second cause of action, and you don't mention Mr. Feinberg. In fact, he's not mentioned by name as having done anything in your complaint unless I missed it, apart from having been a co-founder of the KIPP's theory. So I don't understand what your cause of action, what your allegations are that would lead to any claims being sustained as to Mr. Feinberg.
Individually.
Individually, yeah, sorry.
Let me address that. And I think here I need to address first what is in the complaint, what's specifically alleged and what favorable inferences can be drawn from it, and then also to cite you to a couple of pages of the record involving this documentary evidence.
Let's try to be concise.
Yes, ma'am.
So that you don't run out of time.
Yes, Your Honor.
Okay, the complaint doesn't allege anything against Mr. Feinberg.
I would assert that the complaint does, at least through inferences alleged against Feinberg. We go into great detail about the history of how KIPP, the Knowledge is Power program.
So am I correct that you're agreeing that there's no verbatim allegation against Mr. Feinberg, and we can only draw a conclusion that he might be liable for something by drawing inferences? Is that right?
Yes.
Okay.
Yes, I'd concede
and what
that.
principle allows us to do that?
Well, here's where I think, here's where it's interesting, shall we say, in this case. The defendants, the appellant here, brought into the record this documentary evidence, which we had no knowledge of because obviously discovery hadn't taken place yet. And so the trademark license agreement, the articles of incorporation, in the articles of incorporation, for example, for the year 2000, Mr. Feinberg is identified as a co-founder of KIPP Academy, as well as he and Mr. Levin, as Mr. Levin is as well, and that they are both can appoint directors to the KIPP Foundation. The trademark license agreement, and I think this is really essential to this appeal and to counteracting why any argument that the lower court should be overturned in their decision to let this case go forward. The trademark license agreement, which they proffered, goes at great length about the quality control aspect of the trademark license agreement. The trademark license agreement quality control provisions identify Mr. Levin and Mr. Feinberg as the sole members of the Quality Control Committee. And I would ask the court to look at those provisions carefully and hopefully to see that they affirm that Mr. Levin was, as at the Jane Doe 2 arguments, the presiding judge kept asking, well, who was in the building? Mr. Levin was in the building when this culture of abuse, this environment that was allowing this abuse to
Counsel, you have yet to say anything about Mr. Feinberg.
Yeah, it is what it is. Thank you.
We'll rest on the record then.
I think there's no question that at minimum, Mr. Feinberg should be dismissed. But that's also true of the
I'm curious, under the license documents which you proffered on the motion for summary judgment, it said, among other things, that Mr. Feinberg was a permanent member of the License Compliance Committee, he or his designee. So why didn't that give him a duty to monitor whether the school was implementing the foundation's standard and philosophy of education, which in these circumstances might make him responsible for what occurred?
Because under the trademark license agreement, right, we have to understand what is the purpose of the trademark license agreement. What is it for, right? The 5 pillars, they're not student discipline policies. That's what this court was looking to in Jane Doe 3. There's nothing about disciplining students that we're permitted to do.
Are we talking about disciplining students or sexual abuse?
Both. There's, right? We are the
Counsel,
foundation.
there's nothing here that concerns disciplining students. It
Correct.
concerns disciplining a teacher.
And
Not in
setting student safety policies.
Yeah.
Correct. There's not.
Specifically said in Jane Doe 3, which you seem to not be including in the relevant factors. Student safety policies was a significant part of our decision in that case.
Yes, and I'm using that to my advantage because, right, because the trademark license agreement, okay, I have it here. Those aren't student safety policies. The 5 pillars are not student safety policies. They don't have anything to do with hiring people. They don't have anything to do with supervising children, right? We also have the charter, okay? The charter from the academy says the academy's board of directors, that's who hires, fires, etc., right, people. The 5 pillars are not student safety policies. And also, if I may have 30 seconds perhaps, we did exist in Jane Doe 3. The court recognized that. We existed for 5 months. Justices Gesmer and Gonzalez were on the panel. We existed for 5 months, from April of 2000.
Judge Manzanette Daniels, you mean, not Judge Gonzalez.
I have it here. It says Justices Gesmer and Gonzalez were on the Jane Doe 3 panel.
That's wrong.
We existed from April of 2000 through September of 2000. The court said, even though, notwithstanding the dismissal of the foundation, based on documentary evidence proving that we didn't exist prior to April 2000, there's still no basis for the foundation to be liable because the plaintiff failed her initial burden of alleging that the foundation was responsible for setting student safety policies or hiring, firing, training, supervising, or disciplining staff. We're not even alleged to have any connection whatsoever with respect to the abuser here. All of the policies that are discussed in the complaint on pages 39 and 40 of the record are implemented by Levin, the individual, prior to the foundation's existence. This court recognized there's a distinction between Mr. Levin, the individual, and Mr. Levin, the foundation employee. That's why Levin was not dismissed from Jane Doe 3, but the foundation was.
Thank you.
Thank you, Your Honor.
Greenland Acid versus Microcloud Hologram. Counsel, court starts at 2 o'clock sharp,
I apologize, Your Honor.
okay? You will get 3 minutes and no rebuttal.
Good morning, Your Honor. Lawrence Xuan from Maroni LLP for Appellate Microcloud. I will address 3 points very briefly. First, the First Department rule on best efforts clause requires 2 things. 1, there must be objective criteria to measure the best efforts. 2, the objective criteria must be present within the 4 corners of the contract. This has been the rule for 2 decades. We said it's 7 cases from this department spanning from 1998 to 2019. Second, there is no objective criteria in the RRA. The 30-day deferral right referenced by both the trial court and respondent is deferring the effectuation of a registration statement, not the filing of a registration statement. It does not provide any objective criteria as to when a party must make best efforts to make the filing.
If you don't make any effort at all, wouldn't that be objective? If there's no effort after multiple requests, that's not objective?
Your Honor, the law is rolling the boat backwards is obviously a breach of.
The question is simple. If there is a request repeatedly, we need you to do X, and your side does nothing, why isn't that proof that you have failed?
Your Honor, the precedent question is whether there's an enforceable best efforts clause. Here, our argument is there's no enforceable best efforts clause.
You do not have a strong argument with that.
Your Honor, just think about if a writer can take as much time as he needs to write a book, but after the completion of the book.
This isn't a book.
Yes,
this was very clear.
It's a registration statement.
This was very clear what had to happen here. The contract language was clear, and your client violated it.
The contract language is our client can defer the effectuation for 30 days, not the filing for 30 days. The only qualifier for the filing is as expeditiously as possible. And that is not.
So you do nothing, and that's expeditious?
Their argument is.
Tell me what your client did that demonstrated any attempt to do anything. Tell me where in the record they did something in response to the request.
Your Honor, this is a motion to.
Counsel, answer my question.
This is a motion to dismiss.
Answer my question. What did they do? And tell me where in the record I can find that action.
In the complaint, there's no allegation of that because plaintiff dropped.
Because they did nothing, is what you're saying.
Motion to dismiss is.
Counsel, you can keep on trying to say the same thing. It doesn't change the court's questions because we've read this record. And your client did absolutely nothing to multiple requests to do what the contract required him to do. So tell me where in the record there is any evidence that he did anything.
There's no allegation in the complaint.
Thank you. I'll hear you on rebuttal. Oh, you have no rebuttal time. 3 minutes. Next. Thank you.
May it please the court, Masawal Tadessa Tarafa for the respondent, Greenland Asset Management Corporation. Just following
I have a question for you, counsel. It seems to me that the standard in the complaint is that the defendant was supposed to do something as expeditiously as possible. Admittedly, that doesn't state a number of days or set any other standard, but is it your position that that's the kind of language that a court interprets all the time, and that if and when this gets to trial, that's the time when that would be interpreted, just as courts interpret all the time what a reasonable time is, or something like that. Is that your position?
No, Your Honor. In fact, the appellant really muddies the water as to what the text is. But text is clear. It has the proviso of the 30-day deadline after a semicolon, after listing 3 obligations.
So it's expeditiously as possible, but no more than 30 days.
Correct, Your Honor. And it's very clear from the punctuation and the text that the 3 series of obligations only have the 30-day deferral period, and even that is subject to them providing my client a certificate that explains why deferral is appropriate. And clearly, for years, no response or even an excuse is provided as to why a simple filing of a statement has not been made. If I may address the second claim on the implied covenant, they make a number of arguments there, but the first is that the contract itself requires a Rule 144 legend removal process. The contract does not. It does refer to Rule 144 as one of the things that my client or investors can request in lieu of a registration or other reports that they may request their company.
Counsel, there were 6 demands sent to the defendant to exercise its demand for a registration, that a registration's, registration rights statement be filed, am I right?
That's correct, Your Honor.
Was there ever any response to those demands?
No, just a confirmation of receipt. No response, no explanation for why the very essence of the contract, the name of the contract itself is a right to register statement, was not made.
To be clear, that registration was required so that your client could sell.
Exactly, Your Honor. The whole purpose of this transaction is that my client organizes a company to list it, and after the IPO, gets the exercise to trade the shares. And those shares are
sell their shares.
Exactly, Your Honor.
And what happened here was your adversary refused to file that registration so that he could sell his shares without having your client's shares in the market with which he had to compete.
And the consequence is that millions of value of my client are stuck in the process, and the implied covenant of fair dealing that's established in New York law applies even when a contract says the other side has some discretion. We cited a number of cases that say this implied covenant applies even when a party has some discretion, but that discretion has to be exercised reasonably and in good faith. Not in bad faith, Your Honor. I rest my case. Thank you.
Stevens, no. State of New York versus Daniel M.
May it please the court. My name is Naomi Weinstein. I represent Daniel M. in this appeal. The state here wholly failed to prove by clear and convincing evidence that Mr. M is a dangerous sex offender requiring confinement. What was clearly demonstrated in the record below is that Mr. M is now 72 years old and was demonstrating documented cognitive decline upon his release into the community. This is someone who spent over 35 years incarcerated.
More about this documented cognitive decline that seemed to only affect him when he had to go to sex treatment.
Yes, Your Honor. So immediately upon release in October 2021, it was documented by, and this is in Dr. Mildress's report that is in evidence before this court, it was documented that Mr. M's shelter, so he lived in a shelter in the Bronx, and he was expected at first to, I believe, attend sex offender treatment in Brooklyn, and then it was moved to Lower Manhattan. But it was documented shortly upon his release that he was getting lost on a daily basis. And that confusion was documented throughout the record. For example, he would show up when it was a holiday. He also had a documented, about 4 months after his release, he had a documented cognitive bleed that required hospitalization. And OMH itself was concerned about his need for assistance, that they recommended him shortly upon his release for case management services, but they never implemented such services.
So let me ask you the following. The record indicates that that the respondent missed 19 mandatory individual and group therapy sessions during 10 months, that he was disruptive when present, did not engage, discuss his sex offending, and made inappropriate remarks to the staff, okay? Did the respondent also miss his appointments with his parole officer?
I believe there was no representation that he missed parole officer. However,
Which means that, according to the documentation that we have before us, he missed sex treatment, sex offender treatment, but made all the visits, all the mandatory interviews and visits with his parole officer.
so correct, Your Honor. What the state and
Doesn't the record also show that the shelter, that the staff at the shelter provided him assistance to reporting to parole on time, but didn't provide him any comparable assistance in getting to his sex offender treatments?
That is correct. There was no transportation provided for Mr. M. There was no accommodation such as allowing him to attend treatment virtually. Regarding the missed sessions, that is the basis for this cyst violation. And the court has made it clear that when there is a non-sexual cyst violation, there has to be a close causal connection between that.
Well, that's an issue, right? Whether it's non-sexual, right? So where I have someone who has a history of the most horrific abuses against children that I have ever seen, right? And the photographs he chooses to put in his phone are of children. I don't see how there is a disconnect between his prior abuses and this behavior.
So if I could just correct one thing, he was not putting photos of children on his phone. He was found, he discloses to his treatment team, he found a phone on the lock screen, there was a picture of a child, he was trying to return it. There was also an incident
It wasn't just one phone, counsel. It was several phones. There were several photographs. I've gone through the record. It's more than one child, it's more than one photograph, and it's more than one phone. We also have this man disabling his tracking devices. And he refuses and has refused, according to the record, to tell his parole officer where he was every time he seemed to be off the radar, right? So this isn't just one little thing. This is a lot of things,
So,
right?
and Your Honor, it's our position that this is not willful behavior on Mr. M's. This is directly in correlation with his documented cognitive.
Can I just ask?
Wait a minute, I'm sorry. Disengaging your tracking device is by mistake?
So, Your Honor, what was in the record on cross is that during one of the times where he allegedly tampered with his GPS monitor, it was that he was charging it to a wall, and when he stood up, it broke. But he never absconded, Your Honor. He never was found.
I would love to hear someone from parole on the stand say that it's that easy to break one of these devices.
Can I just ask about the Facebook, that he had Facebook accounts that had a different name, where he was contacting children in other countries? Is that something that just happens, or do you have to figure out how to make that happen?
So, Your Honor, that occurred shortly upon his release. And again, he was in the community for 2 years, and he never sexually misbehaved. And I understand his crimes in 1976 and 1977 and 1986.
as well as serious misconduct in prison.
Which made him stay in jail an additional 9 years at least, from my calculation, okay? Because he's not out not even 1 year, and he molests a 9-year-old and a 13-year-old boy after the outrage. And after the outrage of him raping a 7-month-old baby, okay? So I'm sorry, there should be not one photograph of any child in this person's phone.
If I could just respond, Your Honor, to your question about the Facebook. It was in the document that it's documented in evidence that even his own parole officer did not believe that he knew how to operate a phone. This is somebody who spent 23 years in incarceration, then spent over 10 years, from 2009 until he was released by a court in 2021. He was in the secure treatment facility receiving OMH sex offender treatment at Stark Oakview. And even the parole officer questioned whether he even put the Facebook on his phone, whether he was even really communicating. I think what's important here, Your Honor, I'm not excusing his poor behavior, and it is egregious. There's no question. But this is not punitive, right? This is not felony probation. This is somebody who is expected to go.
Protect the public. It is the whole purpose of CIS is to identify people who, and there's no question that your client has been has been diagnosed with pedophilia. And so we understand, okay, a disease is a disease, right? The same way that someone who is an alcoholic has to keep on going to treatment in order to stay sober. I have someone in front of me who has no insight into his pedophilia, doesn't believe he needs treatment, doesn't go to treatment, whatever excuse, I didn't find the train, they didn't take me there. So, I mean, really? Now we have to start taking people to their treatment? That is untenable for our system, right? And so I am at a loss that his attempted contact with children, and that is not connected to his past.
I see my time is up, Your Honor. If I could just briefly
Yes, you may.
respond. So again, thank you. Again, Mr. M, regarding the mistreatment, this is somebody who, if it was in the record, if he shows up even late, he cannot go. When that counts as an absence. When he does show up late, he tries to go to another treatment like his substance abuse. And Your Honor brought up alcoholism. That played a significant role in both of Mr. M's sex offenses. And it's not nothing that he stayed sober the entire time, the entire 2 years that he was in the community. The alcohol monitor bracelet that Mr. M had on, that's not an ordinary thing like the GPS monitor that's put on everyone. That's only put on people who are identified by OMH as somebody who might be risk of relapse. And so he wasn't engaging. I understand that he should not have had, that the court's point about the incidental contact with minors is concerning. But what you don't have is you don't have him looking at porn on his phone. You don't have any iota of sexual misconduct with
That we
any.
know of, counsel, because of those unaccounted for absences. So here's my concern. I'm going to refer back to the period of incarceration where the defendant received 26 disciplinary tickets from both moderately severe and highly severe violations. And there was sexual misconduct while he was in prison. So we have a defendant who rapes the baby in 1977. In 1986, has sexual contact with a 9-year-old and his brother separately. While incarcerated, he continues with sexual conduct, including exchanging food and commissary benefits for sexual contact with younger incarcerated individuals. Then we have this today, present day. And Dr. Milgis, who testifies for the state, says that while both pedophilic disorder and antisocial personality disorders are chronic conditions that cannot be cured, the urges and risk of offending can be managed through treatment. But here we have pretty much no treatment, minimal treatment. He has contact with a minor post-release who's 11 or 12 years old. He said that she was 16 or 17. He propositioned a young girl in the program, one of the sex treatment programs. He was discharged. He was thrown out of 2 programs. I don't see where you have a leg to stand on.
Because, Your Honor, if I may again respond, regarding the disciplinary tickets, he has not had a disciplinary ticket since 2006, and that was in the record that it was consensual sex. So the last time he was sanctioned for illegal or sexual misconduct was 2002. 2009 to 2021, he was in a secure treatment facility receiving.
I'm sorry, a what facility?
A secure treatment facility, Your Honor, sorry, at Stark Oakview. And so, again, all this information is before the judge in 2021, his whole history. And then we have 2 years in the community. And as Mr. M's expert, Dr. Barr, testified, you don't have one instance of any sexual misconduct. Regarding what Your Honor referred to, I'd just like to slightly correct. He was sanctioned for propositioning an adult in the program who turned down his sexual advances. And so he never pursued it further. He was the one himself reporting the phones and everything to his treatment provider, to his parole provider. He wasn't hiding anything. Even when his GPS monitor wasn't working, he never absconded. He never was.
None of those resulted in any, in an initiation of a cyst violation, correct?
Correct, Your Honor. There were many cyst incidents reports, but the cyst violation, and of course this court can take into account his whole history. I'm not arguing that it can't. But when you look at what is bringing this matter before and what the state has a high burden by clear and convincing evidence to show is the cyst violation itself, which was failure to attend treatment on time. And as the Court of Appeals held in Michael M., transportation issues causing issues for someone to attend sex offender treatment is not enough to find that they have a current inability to control sex offending conduct. Thank you.
Good afternoon, and may it please the court. Blair Greenwald on behalf of the state. This court should affirm Supreme Court's decision relying on the state expert's opinion and finding that respondent is.
Well, the hearing officer, the judge found both psychologists to be, mental health professionals to be credible, correct? This is not a situation where the court found that one mental health professional was credible and the other was not. In fact, he explicitly said they were both credible, correct?
He said that credible in the sense of testifying, he believed that they were.
That's the standard that judges are supposed to apply, correct?
Well, except that the decision is fairly clear that Supreme Court did not believe the Dr. Bard's opinion.
So we're not supposed to give any credit to his statement that the doctor.
Court clearly accepted the other doctor's opinion over Dr. Bard's. That was clear from the judge's opinion.
So we're not supposed to pay any attention to the judge saying that Dr. Bard was credible?
The court reads it in context, right? So the rest of the opinion goes on to specifically.
I read the whole opinion, counsel.
Correct, Your Honor. So I'd also just like to correct a few things here. One is that there's ample record evidence for the finding of dangerousness.
Counsel, and what I was struck by was that these various incidents that occurred during the time that Mr. M was on cyst did not result in a parole officer ever filing for a cyst violation or seeking a petition for confinement based on any of those, but only with regard to the alleged failure to attend sexual offender treatment. Is that right?
That makes sense, particularly in the context of this pedophilia.
Well, I don't know if it makes sense or not, but do you agree that no other violations were filed for any of these events, including the alleged Facebook incident and so on?
So as explained in the testimony,
do you agree that there was no other violation filed during the time he was on cyst?
No. So those incident reports document violations. There was no formal charge.
That's what I'm talking about, a formal charge.
And that's correct, Your Honor. These incident reports document all of the violations of cyst. They don't necessarily result in a petition for confinement.
Would you agree, counsel, that we certainly don't want parole in this context to throw a defendant in jail when there's one violation? You want parole to give them a little rope and see if they will fall in line and self-correct.
That's precisely correct. And Dr. Milch's testimony explains exactly this, how the respondent here was not
responding. Sorry, whose testimony?
Excuse me, Your Honor?
Whose testimony?
Dr. Milch, the state expert, Your Honor.
I thought you said, okay, I thought you used a different name, sorry.
So the state expert explained that the respondent here was not engaging and meaningfully benefiting from treatment. His risk was not going down as you would expect it to do.
Would you agree that he had completed sex offender treatment when he was in prison?
He completed a 2011 program.
Okay, and would you also agree that he was recorded as not having been there if he got there late?
That's correct. He was also.
And so even if he said, I understand there's another program going on, may I join that program, and they turned it down, he was still listed as not being there, right?
That's correct, and yet, even when he was there, it was documented that he was disruptive, would not discuss his sex offending, and engaged in problematic behavior with staff. It was also documented that he was able to attend his substance abuse treatment.
Was the sex offender treatment one of the conditions of his parole for cyst?
Yes, Your Honor.
So that in order to stay on cyst, one of the primary conditions was that he participate meaningfully in sex offender treatment, correct? Yes, and would I be incorrect in saying that one of the best ways of assisting someone who is suffering from pedophilia is continued sex offender treatment in order so that this person can continue to engage in dialogue about their thoughts, their, all of the behavior that may be running through their mind that they should be steering away from. Being in treatment assists them in identifying the danger marks and in reaching out for help when they are in the danger zone.
Precisely. In fact, behavioral sex offender treatment is the primary way to control and manage pedophilic disorder.
Counsel, let me reflect with you on one of the responses by your friend here to my question as to the comparing treatment or attendance at the sex offender treatment programs. Well, it's plural, right, because there were two. And then the showing up to the parole officer meetings. Counsel says, well, there was assistance by the shelter so that the respondent would appear at the parole officer meetings, but nothing was provided with respect to the sex offender treatment programs. Is that something that we need to take into consideration?
I'd like to correct something. So
Please.
it's not that he received, shelters escorting him to the parole office. He was reminded, and the same happened with the sex offender treatment. The parole officer made accommodations not only to simplify the schedule, but also
Where is
made
that in the
frequent
record?
calls.
Where is the where does that appear on the record?
So Appendix 393 to 394 and 396 to 398, the parole officer made frequent calls to the respondent to prompt him to go to treatment and provided him with a written calendar as well. The evidence here shows that respondent was capable of going to his substance abuse program at the same exact facility, just without these kinds of reminders. So he was clearly capable.
Same facility that he got lost going to for sex offender treatment?
Yes, Your Honor.
He was able to find it when it was drug treatment?
Yes, Your Honor.
Was he aware that any violation of the conditions of CIS could result in him being civilly confined?
Yes, Your Honor. That's actually written into the CIS conditions, which he signed.
Counsel, one of the things that's been raised by your friend was the fact that his inability to meet his obligations under CIS occurred due to a brain bleed. So they're suggesting some kind of physical condition affected his cognitive ability to honor his CIS obligation. You recall that in the record?
Their argument?
The argument.
Yes, Your Honor.
And they said he was confused, but as been pointed out by some of the questions you've been asked, he's selective in his confusion, correct?
That's correct, Your Honor.
He was able to get to parole or maybe drug treatment, but he just couldn't find his way for sex offender treatment.
Which is also consistent with his own admissions that he doesn't need treatment and that he doesn't want to engage in treatment. And these statements he made after the brain bleed.
Thank you.
I'm sorry, after the what?
After the brain bleed, Your Honor.
Thank you so much. You have 2 minutes.
Thank you, Your Honor. I just want to briefly respond. The court was obligated under Article 10 to consider all the conditions of CIS that could be put in place as part of Mr. M's because the state failed to prove that he was a dangerous sex offender and that he doesn't have an inability to control sex offending conduct. There's a lot being imported onto Mr. M as to his willfulness, rather than what's not contested is that he was displaying cognitive issues. And again, his parole officers in the Bronx, the parole offices in the Bronx that he is to report to, the church that that the state mentions in their papers, that's around the corner in the Bronx. And while there is testimony that he attended substance abuse treatment at the same place, it's not clear from the record whether that was first thing in the morning, like a sex offender treatment where he has to be there at 9 a.m. or he's late. There was nothing in the record that indicates it was first thing in the morning. And what, again, is important is that, and what the state completely minimizes, is the fact that he wasn't engaging in risk behavior like engaging in alcohol. And again, this is not your typical sex offender. This is somebody who spent 35 years confined. He spent over 11, almost 12 years in a secure treatment facility, as in Article 10 dangerous sex offender requiring confinement. He spent over 12 years before a court decided that he was ready to be released. And while he did have these incident reports generated, what's before this court is whether currently he's displaying the fact that he was not able to attend sex offender treatment on time, if that shows he has an inability to control his sex offending behavior.
And Dr. Bard had previously interviewed Mr. M, correct?
That's correct.
And at that time, he had found him to be dangerous.
That's correct.
And his report at this time went on to find that there had been significant changes both in his cognition and in his behavior.
That's correct.
Can you talk about that?
Dr. Bard evaluated Mr. M approximately 10 years prior while he was at, while he was at Stark Oakview as part of the annual review that is granted to him up there. And at that time, Dr. Bard opined that he was still a dangerous sex offender requiring confinement. Fast forward to 2021, where a court releases him, Dr. Bard is seeing him for the first time in 10 years and notes how stark of a contrast his cognition is, and does, although he admits he does not have neurological training, does like a mini mental status, and notes how forgetful Mr. M is. Even Dr. Mildus admitted that there were times throughout his interview where he didn't even understand the question, no matter if it was translated into Spanish, no matter how many times it was explained to him. Dr. Mildus also admitted that the evaluation was terminated by Rikers, and that he never attempted, after about an hour and a half, and never attempted to try to clear up some of those things. And so this is somebody who, yes, he was not following the cyst order as it was prescribed. But again, the state has a high burden to show that even any of those rule breaking shows that he has an inability to control sex offending behavior. Again, with his over decade plus, including the sex offender
You are
treatment
not arguing that a court has to find that there was sexual misconduct in order for there to be a finding that he is dangerous.
No, Your Honor, of course not. But of course, there has to be some sort of behavior. For example, in Mr. M's specific case, engaging in alcohol, when he has a monitor bracelet that they thought it was such a problem, they put on a bracelet to see if he was immediately drinking alcohol, the parole officer would be notified. Or, for example, looking at pornography.
Look, as I said earlier, and I don't want to belabor it, I am very disturbed with the unexplained absences of your client when his GPS wasn't working, and his failure to provide the parole office with an answer as to where he was during those times. That is what the record shows. So, but I have your arguments, and I thank you.
Thank you.
Lerena versus 975 Park Avenue.
Good afternoon, Your Honors. May it please the court. Beth Gehrig for the defendant, appellant, respondent. Even though our appeal is limited just to the 200 issue, I would like to concede to this court that there was an error in our brief below, which is pointed out by our adversary to save Mr. Isaac some time. It is true that the 241-6 claim predicated on that one industrial code section is still alive. The court found that there was a question of fact.
Okay.
As far as our 200 claim, the only reason why the lower court found that Nova was responsible or had to stay in the case with regard to the 200 claim was because of the general supervisory language in the contract.
There's really no dispute on this record that Costin and Monzon were really controlling everything that the plaintiff was doing here, correct?
Absolutely.
And while Nova had that contractual responsibility, there's not a shred of evidence to suggest that Nova had anything to do with the means and methods here.
Absolutely. And even though plaintiff argued in their brief that this was a premises condition, it's not. So unless you have any other questions, I think you understand my arguments there, and I will save the rest of my time for rebuttal.
Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff, respondent, appellant. Let me start with my appeal first, and then I can deal with the 200. This court, pre-runner and post-runner, has held that in situations like this, Labor Law 240 is applicable, even in situations where the plaintiff doesn't fall or where he's not struck by a falling object.
So the Interiano case would help you then?
I think Interiano is outcome determinative, Judge Schulman here, although let me be fair. In Interiano, there was testimony that the scaffold was moving and that complaints were made. We don't have that here, but it's an absolute liability statute, right? Since McNair against Solomon, 1998, you said that the movement of a ladder or a safety device is a violation of the statute, and it's a 240 claim. So I have no idea why my 240 sub 1 claim is dismissed, because the trial court can't ignore your precedent. But there's no question here that it's a 240 claim. Let's talk about Mr. Monzone's affidavit. I have it here. First, I don't think it should have been considered. I understand that his name was mentioned in the deposition, and I also went back and I read the...
Let's say it comes in.
Okay.
Tell me why it doesn't matter anyway.
It doesn't dispute what the plaintiff said. Look at 314, paragraph 4. I'll read it. Immediately after the incident, I inspected the suspended scaffold on which plaintiff was working and found that it was secured to the building wall at either end of the suspended scaffold with expansion bolts, and the scaffold was firmly in place against the wall. It did not move during my inspection. That's what the plaintiff said, 171 to 173. He didn't say that the scaffold was flying all over the place. He didn't say there was a problem. He said it was working perfectly until I put the chipping gun in, it moved, it went back a foot, the gun got stuck, I hurt my shoulder, and then I fell. That's the exact same facts as in Interiano.
Is this an elevated risk, what happened?
Yes, it is, because he's up on an elevation. This court has said that that's an elevation risk, irrespective of whether there's a falling object or a fall. And as a matter of fact, I'm sorry, there is another case that you decided called Lind. It's at 180, which was somebody was in an elevated platform. There was a problem with the brakes, and the plaintiff didn't fall, just ricocheted around, and you've granted summary judgment there too. So the answer is yes, it's absolutely an elevation-related risk under this court's jurisprudence, and there's no dispute about what happened. So my view
Our
is...
case law doesn't require any, doesn't have a de minimis fall standard, so that I believe it was a she, falling into the scaffold itself is irrelevant.
Irrelevant.
We've had other cases with people falling in the scaffold itself, and we still found 240 sub 1 liability.
Absolutely correct. One other point, there's a new case that came down that I gave to Ms. Gehrig. I also provided the court with it. It's called Pilla Panta against Hudson 888 owners. I'm sorry, Your Honors, all I have is a Lexus site because it's new. 2025, New York Active Lexus 6154. Last sentence, if I could read it to you. Plaintiff's supervisor's testimony that the ladder was still standing when he arrived at the scene of the accident does not undermine plaintiff's proof that the ladder shifted unexpectedly, causing him to fall, and it was therefore not an adequate safety device for the task at hand. That should be followed here. Judge Schulman, you spoke about Labor Law 200. Let me make it easy. I don't necessarily disagree with what you're saying. The trial court, I'm not sure disagree with what you're saying either, just denied summary judgment on procedural basis. But to the extent that you find that it was preserved and there's a problem, I don't take any exception with that. If you have no more questions, I'll sit down, rest on my brief.
With regard to the 240 subsection 1, plaintiff did not fall here because of a gravity-related incident. Plaintiff's testimony was clear. He was using the chipping gun. He's on suspended scaffolding, so there's going to be some degree of sway. The cases that the plaintiff is relying on deal with fixed ladders, which are not expected to move.
But if he had not been on the scaffold, then the gun he was using getting caught would not have caused him to fall, correct?
We don't necessarily know that, because based on his testimony, he's using it. It's like a jackhammer.
Yeah, I understand that. And part of the reason that then caused him to fall is that he's up in the air on a scaffold, which moves.
He says that he's using it, it gets caught in a hole next to it.
Right, and the reason that caused him to fall is because he was on a scaffold that was moving.
Well, that's the key here. It caused the jackhammer to move and get caught into the nail. And then his testimony was clear that the reason why he went to the ground, is because he felt pain. On page 173.
It doesn't matter. It doesn't matter. We've had things fall on top of people, it's hurting, and then they fall. Of course it hurts. That's not the issue. It doesn't matter that his body reacts to the pain. He gets a pushback from the gun getting caught up in the hole of the brick.
If he had said that, Your Honor, I would agree with you. But he didn't say that the pushback pushed him against the wall or the.
There was no wall. He was on a scaffold.
It didn't push him against the safety wall of the scaffold. What he said was, I fell to the ground because I was in pain. So it got caught, he separated his shoulder, and then he went to the ground. I think
So counsel, let's make it easy. The scaffold's not supposed to move, period. End of story, unless one intentionally makes it go up or makes it go down. So here, if it goes back from the wall 1 foot, we have a problem.
Respectfully, Your Honor, here the key thing, I think, is whether or not the safety device malfunctioned. The very
No, it's whether the safety device served
adequate.
its purpose and adequately protected the worker. That's what our case law has said for a gazillion years.
One of the cases that Mr. Isaac gave to me last night, and I think it's important for us to take a look at it, which is in the Rom case from this court, 158 AD 3D 570. It says here, whereas here a ladder collapses or malfunctions for no apparent reason. The very essence.
That is one of the circumstances. We have a lot of ladder cases and scaffold cases, and there are a million different fact patterns. So no one case locks out another case. It's all dependent on the facts. And I noticed that you have not addressed the most recent case that I think is completely on point.
The Inzerato case? Absolutely did address it in our papers, and in Inzerato, the testimony was clear. It was not tied in. What I'm trying to get to here, Your Honors, is basically with these types of scaffolds, with the hanging scaffold, they are not permanently fixed. There is some sort of sway, there is some sort of give. Now I recognize we have to.
So that's a problem. Some sort of sway, some sort of give, if it's sufficient to, how would you say, make the scaffold not fulfill its primary use, which is to protect the worker, then we have a problem. We have a labor law violation.
As much as I hate to make a policy argument, here I think that's what we have to look at. Suspended scaffoldings are not fixed. They're not completely.
But it's the labor law 240(1) in particular is a strict liability statute.
But then.
So that no policy, the policy is clear in the statute.
So then essentially what Your Honors are saying is that anytime somebody is on a suspended scaffold, which is a permitted type of scaffold, it is completely understood in the industrial code is an accepted scaffold. It's going to have some sort of degree of sway because you have to move it, even when it's tied in. And all the testimony here is that this is tied in. So even though you have some degree of movement, anytime somebody's on a suspended scaffold, when it's serving its actual purpose, and its purpose is it's not a fixed scaffold, there's automatic liability. Essentially what we're saying is you're on a suspended scaffold, you're injured, you're out of luck, sorry defendants, you're not going to be able to use these anymore. Insurance premiums are going to go through the roof. Nobody's going to be able to be on a suspended scaffold. How else was this work supposed to be done?
Counsel? You're giving us a summation or a policy argument that is better suited to the legislature, because this court can't change the statute as it is. It is what it is. If you think it is wrong, I leave it to you and the lobbyists that do this to talk to the legislature.
I understand, and just.
Thank you so much. FlexJet LLC versus Honeywell.
Your Honor, Rachel Fritzler, on behalf of Appellant Honeywell, I would respectfully move the court for permission for my partner, Mr. John O'Quinn, to present the argument on behalf of Appellant.
And he hails from where?
He is from Washington, D.C., is admitted to the bars of North Carolina and the District of Columbia.
Your application is granted and you are welcome, sir.
Thank you, Your Honor.
You may proceed.
Thank you, Justice Manzanet Daniels, and may it please the court, John O'Quinn on behalf of Honeywell. The lower court's interpretation of the parties' services agreement here is wrong. The court seemed to think that the contract's termination for convenience provision was inherently incompatible with its duration provision. But that's simply wrong under New York law. No case says that, indeed quite the opposite.
Well, I think we need to focus on the fact that there was a clear change in the MSA that was clearly negotiated between the parties to put in, and I'm being overly simplistic, to put in the 10-year term and the 15-year repair term unless the FlexJet is not in good standing, in compliance with its obligations under the MSA. That's very different, even though you incorporated by reference the GTA, but that was a very focused change here.
So Justice Schulman, so 2 points. First, with respect to the language in Section 3, Section 3 of the MSA.
3.1 versus 30.
3.1 of the MSA. And when you say a change, I don't take you to be comparing it to this other agreement that they refer to called the FASA. That's extrinsic evidence. We could talk about that if we get to extrinsic evidence. But with respect to Section 3.1, it does two things. It identifies two term provisions, 10 years for enrollment, 15 years for service. With enrollment, it adds a good standing condition precedent.
And that's the only condition that it adds that permits termination. There's nothing about convenience.
Yeah, so Justice Gassmer, 2 points. First of all, it is what it's doing is adding a condition precedent. It's not a termination provision. In fact, the other side actually concedes in their brief that it's not a termination provision, that it's a condition precedent. The reason that it's there, it's separating out two different functions. It's saying that if they are not in good standing, whatever obligation to enroll that we have, we don't have to do it. So for example, if they're behind on their payments, we don't have to enroll new engines. We can do that without using the
That's
blunt.
not the issue here, right?
That's not the issue
So
here.
let's move on to what is the issue here.
Yeah, but
you have 3 minutes left, and you're not getting to the meat of this case.
So,
It's up to you.
so Justice Manzanet Daniels, I think the meat of it is that a termination provision, and is it exclusive with the termination for convenience?
Counsel, Mr. Hurst, when he testified on behalf of Honeywell, said two things. One, that there was no need to duplicate the language of the GTA.
That's right.
And two, that Honeywell was free to terminate the MSA for convenience the next day after, the very next day, even if they had accepted $10 million from FlexJet. So in other words, FlexJet could pay $10 million, and on grounds of convenience, Honeywell could terminate the contract the next day. We typically see contracts that do repeat the language that is meant to be included in a contract. And here you are asking us to add language to Section 30.1 of the MSA. Why is that appropriate here?
Yeah, so there's a lot packed in that question, Justice Gonzalez. Let me take a couple of points. First, with respect to the idea that you could terminate the next day, that was actually that was the statement of counsel. It wasn't his response.
Mr. Hurst said that.
So you disagree with that statement?
I do disagree with that statement. He absolutely, first of all, termination requires 30 days notice. Second of all, with respect to enrollment, if they enroll,
Wait, are you saying that in her fact pattern, that after they signed, with 30 days notice, you received $10 million, you could just say, out of convenience, I'm done? Is that what you're saying?
Not and keep the money. No, I'm not saying that.
Okay, because I'm rereferring to the record.
right.
I'm referring to the record.
I'm trying to see how far you're going to go. So go ahead.
Page 2538.
Correct. And the witness, who's not a lawyer, was just making the point that.
No, he was just the chief executive, right?
I don't believe that's, I don't want to call it Justice Gonzalez, But with respect to, he's certainly not a lawyer, and all he was making the point is that the parties had preserved a right to terminate for convenience. That doesn't mean that you could take the money and not perform any services. And indeed, under the enrollment, the way the enrollment would work is you would then, they would pay, and enrollment would happen, and you would have 4 days to perform the service. You can't terminate except for 30 days in the future.
Thank you for the clarification.
Service would have been performed. But at the end of the day, the termination for convenience is incorporated by reference at the beginning and end of the MSA. Section 1.1, right up front, says every single term, including termination for convenience, has been incorporated by reference. And so then the question is, does having the good standing provision create some kind of inconsistency? It doesn't. What it allows the party to do is to not enroll engines, but not use the blunt instrument of termination to kill the whole agreement. So that if they were behind on payments, you could stop with any obligation to enroll.
So you're saying that there was no inconsistency between 30.1 of the GTA and 3.1 of the MSA?
That is exactly our position. There is no inconsistency.
And therefore, you are saying that the descending order of precedence was not triggered?
That's exactly right. Just like in the Steele-Warwick versus Microgenics case that we cite in our brief, you don't even get to the order of precedence because there is no conflict. There's no inherent conflict between having between having a termination for convenience provision and also having a good standing condition precedent. And even if you treat the good standing condition precedent as actually being termination, there's nothing inconsistent. Indeed, in the GTA itself, you have termination as of right for convenience, sitting alongside termination for default, sitting along termination for violation of a condition precedent. Those are not mutually inconsistent.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. William Adams for FlexJet. The Supreme Court got it exactly right here in finding that the MSA Section 3.1 displaced the termination for convenience provision in the GTA. We know that for several reasons, but first I want to dispel the notion from the other side that Section 3.1 is just a term agreement. It's as if the agreement just provides for a duration of 10 or 15 years. But it simply doesn't do that. And as Justice Shulman, as you pointed out, the language is very different here. It's a bespoke agreement. It doesn't simply say, this is for a term of years. It expires after 5 years. It shall be in full force and effect until December 31st, 2000, or whatever date. In fact, this agreement provides express obligations that have a durational component.
Counsel, isn't it fair to say that, and I went through a lot of the record in terms of the back and forth as they were trying to frame the MSA as an attachment and something that's than more than just supplement, and whereas the GTA is a supplement.
The GTA is the framework of the initial agreement.
Oh, so it's fair to say that there's something interesting about the fact that Honeywell is asking for all this money up front without even doing a thing.
Exactly, Your Honor.
We're talking about millions of dollars for the enrollment, and then suddenly for you folk to say after we put all this money in that they could just cut us off the knees.
Absolutely, Your Honor. And there are cases where they have standard durational contracts are like standard service arrangements where you need to go clean Penn Station or pick up garbage or something like that. This is a very unique maintenance requirements that are fulfilling FAA obligations where my client needed certainty that when their engines needed repair, they could look to Honeywell for those repairs. And that's exactly why they insisted upon a long-term arrangement so they wouldn't be stuck with these engines in the middle of their life, which run from 10 to 20 years as the lifetime of an engine.
Is there any evidence that your client failed to perform in any way?
No, absolutely not, Your Honor. There's been no allegation or any evidence that we failed to perform. They did not say that the MSA or the GTA was no longer in good standing, which, back to Justice Gessner's point, is the sole reason in which their performance would be excused. But they didn't allege that if there's no evidence of that, and so that's frankly not at issue here.
And so, in fact, stated the grounds was convenience, which means there were no grounds.
Exactly. When they put in their notice of termination well into this litigation, if they thought they had a real termination right as of convenience, you would have thought they would have done it long before the filing of this suit and accumulation of liquidated damages, which we'll get to in a separate appeal.
Counsel, there's three things. First of all, is there any kind of language that incorporates 30.1 into 3.1 or into the GTA into the MSA? Is there merger language that says everything that's in the GTA is incorporated into
The GTA is incorporated into the MSA, except that there in section 13.1 it has the order of precedence provision, which provides that if there is any inconsistency between the agreements, that the MSA trumps, and the first recital clause in the MSA says that the GTA is expressly subordinate to the MSA.
Yes.
So the GTA comes first. It's the framework agreement, but that's just boilerplate. There was extensive negotiations over the MSA and with respect to 3.1 specifically, in
And
which
that language, I was just going to say it was deleted.
Exactly. That's where I was going to go next, Your Honor. Not only is the language that they want to import into the MSA, not only is it absent from the agreement, it's present in the FOSSA, which we don't think is extrinsic evidence because it's part of the whole family of agreements. You can look to the Western and Southern life insurance case from this court, which looks to similar agreements that was expressly endorsed by the Court of Appeals in IBK. So it's not extrinsic evidence. But what is extrinsic evidence, but absolutely shows the negotiating history, was at 2758, where they strike the language that they would want to import into this agreement, and they did so in response to my client's insistence that there be a long-term arrangement for the maintenance of its engines, so it's not left high and dry just like it was here. So putting it all together, you don't need to go to the extrinsic evidence here. We think it's absolutely unambiguous that this is not just a durational provision, but it also imposes obligations to enroll aircraft and to service them for 10 and 15 years respectively. And we think that language is clear also, particularly in relation to the FOSSA. But if you had any doubt about that, the unambiguous extrinsic evidence all points in our favor. And to the extent the other side has another theory, Justice Gonzalez, as what you were alluding to earlier, about that it was replaced because it was duplicative in some sense, that's unexpressed subjective intent. At record pages 131 to 132, Mr. Hurst admits that he did not convey that. He doesn't have any recollection of conveying that to FlexJet. So his mental impressions, which only come out in deposition testimony, unlike the contemporaneous evidence that we have, would not create a triable issue were there any ambiguity. If the court has no further questions, I'd urge you to affirm.
Thank you.
Thank you, Your Honor. So, Justice Gonzalez, your question, is the GTA incorporated by reference into the MSA? Absolutely it is. Section 1.1 incorporates all of the terms of the GTA into the MSA specifically.
So then what do we do with the language that was deleted on record page 2758, deleted unless either party uses its right to terminate this agreement as set forth in the GTA?
Yeah, so Justice Gonzalez, that language is in the so-called FOSSA agreement. It is extrinsic evidence. It is not part of this agreement. And if you had any doubt about that, if you look at section 38 of the GTA, it says that the terms of one attachment don't apply to, modify, supersede, or have effect on another attachment. It's an entirely separate agreement at a different point in time for a different subject. It wasn't a service agreement. It was an IP license. It is simply that change from that is simply irrelevant. The question before the court is the GTA term incorporated? Yes. Was this negotiated against the backdrop of the GTA? Did we, yes, it was. Did we need to repeat it? No, we didn't. And it was also negotiated against the background principle of New York law. The duration provisions are not inherently inconsistent.
There's a third question, which is there an inconsistency between the GTA and the MSA?
Justice Gonzalez, you took the words right out of my mouth. That is ultimately the controlling question here. That's the third point. Because if they are inconsistent, then yes, I agree. The order of precedence clause would apply. But they are not inconsistent. All you have is a duration provision. Yes, it's broken into two parts. One of those parts addresses service, and it's 15 years. One of those parts addresses enrollment. It's 10 years. There is a good standing condition a precedent to that so that a party could stop enrolling without having to, or stop considering enrolling without having to use the blunt instrument of termination.
Why isn't stopping enrolling another word for termination?
Yeah.
Oh, because there are two entire.
Semantics is what it is.
Not at all. If I'm.
Yes, it is. We end up in the same place. And you're just using, you're using the word in order to excuse fulfilling the contractual language.
If I may, Justice Manzanet Daniels, this contract does much more than do enrollment. It covers enrolled engines, it covers unenrolled engines, it covers service. And what I'm referring to, the good standing provision only addresses the issue of enrolling new engines. It does not address service for engines that were already enrolled, that is enrolled before, for example, one might invoke the good standing condition in order to not enroll engines in the future.
Thank you.
Thank you, Your Honor.
Wilmington Savings versus Lau. Proceed.
Good afternoon. My name is Zong Lau, defendant appellant pro se. My sister's not here. Yui Lau, defendant co-appellant pro se. This consolidated appeal concerns a residential residential mortgage foreclosure action. And I am one of the daughters of the deceased mortgager Sankei Lau, who died intestate. The other person being my sister Yui Lau. We are both appealing the judgment of foreclosure and sale, a sale order, and the denial of our cross motion that sought to cancel the successive notice of pendency filed in July 2024. Our father died post-stipulation, but pre-judgment. The stipulation was filed in 2018, but the judgment was entered on May 5th, 2022. The stipulation also did not have a successors and assigns provision. Now, the crux of the respondent's argument is that the judgment of foreclosure and sale was based on the 2018 stipulation. Now, the respondent is VM Equities LLC, which is not the judgment creditor, and also it was not one of the stipulating parties. It was Wilmington Savings Fund by AMIP. We call them throughout the brief company ABC instead of their actual name VM Equities LLC because they are not licensed by the New York State Department of Financial Services, the state regulator for mortgages, and they are not licensed with the local New York City Department of Consumer Affairs and Workers' Protection to collect any debt of any kind. So we call them pervasively company ABC. They waive deficiency judgment and costs and disbursements. However, deficiency judgment waivers do not prevent a stay of proceedings they do not prevent a stay of proceedings pending substitution of the defendant mortgager. So basically, even if they waive deficiency, which they didn't have any standing to do so, because again,
Why wouldn't they have standing to waive deficiency?
they're not the judgment creditor. They are not one of the stipulating parties. They allege that
They don't have to be the stipulating party if they are the new owner.
They're not the new owner.
Okay.
Their assignment of mortgage still has not been recorded with ACRIS for over 3 years. They are not licensed by the New York State Department of Financial Services, which oversees mortgages, and it's in the record. They said that VM Equities was not found, as well as they are not licensed with the New York City Department of Consumer Affairs to collect debt of any kind. It's simply a DOS registration, an LLC, which anybody can form, but they do not have the proper mortgage registrations. And that's why their assignment of mortgage still has not been recorded. And that's why they are called Company ABC, because it's an illegitimate entity. And they were not one of the stipulating parties. They just kind of came in and said, we own the mortgage. And this is something that's been happening. Anybody can do that. And this is kind of fraudulent. Deficiency judgment waivers do not prevent a stay of proceedings. So even if they did, and they don't have standing to do so, the second department has cited a plethora of case citations that said—
Not the second department.
Excuse me?
We are not bound
I know.
by that case law.
Well, they have said—
This is the first department.
Yes, Judge Daniels. But second department citing them for uniformity of decisions has said that even a party, excuse me, someone who has waived deficiency judgment against the defendant is insufficient. The deceased mortgager would still be considered a necessary party because they would have to have made an absolute conveyance of all their interests, including their equity of redemption, which our father did not. So according to Second Department, one of them is Wells Fargo versus Romden. They state that if the party did not make an absolute conveyance of their interest in the property during their lifetime, you need to go and get an administrator or an executor. And they waive.
Time on rebuttal.
Okay.
Excuse me. Good afternoon, Your Honors. Craig Lons on behalf of the respondent. Your Honor, I'll be as brief as possible. Many of the things that Ms. Lau has said isn't in the record. We are a bona fide assignor pursuant to CPR 1018. That has been indicated, it's all throughout the record. Once we purchased the note, which we paid valuable consideration for, there was no fraud which took place here. We entered into the action and we immediately moved forward on a judgment of foreclosure and sale. Ms. Lau appealed, had that judgment of foreclosure and sale stayed. The appeal was sub judice for some time. It was then determined that Ms. Lau could substitute herself into the appeal, which she has done. And Ms. Lau has had her day in court. This matter was resolved many years ago. It was resolved in 2019. There is an outstanding mortgage that has never been paid here. There is simply no question of that. It is a 15-year-old foreclosure. Ms. Lau, her predecessor, has had many, many opportunities to resolve it. There is no indication.
Has there been any payments on this property at all?
No, Your Honor. And I certainly can't get into settlement discussions, but the clients I represent are always open to resolution. This is something that we work towards. We understand that there's lots of opportunities to resolve unpaid mortgages. That has never happened here. We're not a phony corporation. We are not Corporation ABC. We've participated in this action, and we've participated in it for some time, and our bona fides are part of the record.
So am I correct that your motion for a judgment, that Mr. Lau failed to remit payment, and you then moved for a default judgment, which was granted during his lifetime, correct?
Your Honor, you are correct, except for when you use the word you. Our predecessors.
Yeah,
that was
I
the
meant
case.
you
And of course, that is us. But,
You and everybody.
from a legal standpoint. But yes, that happened some time ago, Your Honors. I really don't have more to add, but if the court has any questions for me, I see them in the white. Yes, Justice Gonzalez.
They're all going to jump on me, but you're still open to speaking with the daughter?
I've reached out to Ms. Lau as soon as we bought the note. Ms. Lau has my number. I'd love to talk to her. I can say that now. We've always want to. That's
not our role.
Exactly, and that's not your role, and it would be inappropriate for me to make arguments based on settlement discussions. But Justice Gonzalez has said that you asked the question. I will answer it, yes. Thank you, Your Honor.
You have a minute.
Yes, that's not correct. There was no default judgment. It was premised on the 2018 stipulation. And the stipulation, CPLR 5016D, states no verdict or decision should be entered against a deceased party unless CPR 3221 applies. And upon looking, the third department citing matter of Uccellini said that stipulations are not covered under that statute. And so therefore, judgment should not have been entered against a deceased party. And there was no default judgment. And actually, the party, your company, ABC, they kind of use a consent to change attorney to get into the action. They are not licensed. Actually, we did apply for financing for Huntington Mortgage. It's in the record. And it is them who flagged and alerted us that they are not licensed, registered with DFS. And they said, going into that, they said, this is not an enforceable note. Be careful, use due diligence. And that's actually why we, he's talking to us, and really what it is a dark web where you create an LLC, they buy the note, and the consent to change attorney did not even have Wilmington's a representative official to sign that. So we're not working with someone like that.
Thank you.